Gray on behalf of from Walters and the Barrow case. Did you want us to start?
So I'm just waiting for the YouTube to kick in, and it is kicking in. So good morning. This is Judge Alyssa Perez presiding over the 210th District Court civil docket for February 25th, 2026. All matters being heard today are being heard in accordance with all directives regarding remote proceedings. In addition to that, we are streaming all matters live via YouTube for public viewing. I'll go ahead and call our first case. It is cause number 2022 DCV 0889 Maria Briseida Navarro Ubaldo et al. Versus FNA Border Transport LLC, Alejandro Isaac Sanchez, Lowhide Logistics, and Trisura Specialty Insurance. May I have announcements, please?
Yes, James Tawney and Hala Abdul Jabbar for the plaintiffs.
Susan Lynn Gray on behalf of FNA Border Transport, Alejandro Sanchez.
Good morning, Kasia Daniec with Meyer LLP representing Lowhide Logistics LLC.
All righty. And so we are scheduled today, as I was kind of informally discussing with counsel, as I can tell, because we've had several filings and the court explained how we've been a little bit out of pocket. So this was actually set last week. And because the court was in trial, we reset it for 1 week at this early time. But I have us down on the motion for summary judgment, Lowhide's motion for summary judgment. Of course, plaintiffs had filed a motion for continuance on that. And then the motion, defense agreed motion for bifurcation. And I know there's a lot of other things that we'll need to talk about. In fact, I kind of felt like plaintiff's motion to compel responses might be related to the motion for continuance, and that is actually set in March 18th. But let's go with what we have right now. So let me start with you, Mr. Tawney, on the motion for continuance.
Yes, Judge. Simply put, I really don't have any documents from Lowhide other than the insurance policies. They produced a couple documents with their actual motion for summary judgment that I had not seen before. I've been trying to work it out with defense counsel, but her position is that she wants a protective order in place. This protective order issue has come up before the court, and on December 8th, 2025, you denied the entry of protective order. So we had a mediation scheduled. I canceled it. It's hard to really take any more depths other than the driver's dep, which we took already, without any documents related to the brokering of this load. And that's where we've been sitting for the last 3 months basically, is that I don't have anything. I don't normally file a motion for sanctions. That's just not my practice. I'm not that kind of lawyer, but I feel that this is against the court's order, and I had a discussion with them about that, and it's hard for me. I feel we have enough already to respond to the summary judgment, to be honest with you, but I don't really want to make a complete record without having these documents because it's not complete.
Okay, so that's the basis, and yes, I saw that the motion, plaintiff's, I guess, motion for discovery and sanctions was filed yesterday, and so many of these issues I suspect are related to include, as I mentioned, the motion to compel that was filed back on the 27th of January. We just haven't quite consolidated everything. Let me ask though, because you mentioned, so I'm understanding the motion for continuance to be that, right? To be that we're missing all these documents and there's, I guess, conflicting positions on what's missing. But you mentioned a protective order. And I do recall we had a hearing either November or December where the court denied Ms. Daniek's request for a protective order at that time. Is there something distinct now? Is it different? Are we talking about different documents, or what are we talking about?
It's the same documents. Nothing has been produced to me, so I haven't even actually seen the documents. Basically, our position is that the protective order was denied, so your objections are not valid, so please produce the documents. You've had an obligation since initially filed under our initial disclosure rules, and her position has been that for her client, she needs a protective order in place, and our position is the court has denied that, so please produce the documents, and that's kind of where we stand. And I don't mean to misrepresent our discussion. If I am, I apologize, but that is without putting any flavor on it, I think that's where we stand.
Okay, Ms. Daniel, let me hear from you.
Yes, I would like to respond, and let's zoom out, as this is a misrepresentation of what really happened. This is an old case. This case was filed back in 2022, I believe March 2022. So we're going on 4 years now. LOHI was disclosed in FNA's production back in early July 2023. Then plaintiff's counsel waits for 7 months and adds LOHI just on the eve of the statute of limitations running to the case as defendant in January 2024. This was prior counsel, so I'm going to just go to the best of my ability of what happened after. There was a remand filed by my client. The case was remanded and was in federal court for 4 months. On May 1st, 2024, it was back in state court. Since then, until late September of 2025, there has been not a single discovery request, not one interrogatory, not a request for deposition, no RFAs, no discovery done on LOHI. There was absolutely nothing. These discovery requests issued in September 2025. At that time, we were noticed that the case was going to be transferred to our law firm. And we did ask for an extension to respond to discovery because we didn't even have the file. Around that time, immediately I reached out to plaintiff's counsel to enter a confidentiality order. That's typical for representation of clients such as LOHI. That was heard and denied. I just don't want to the optics of that our objections to discovery were denied. That's not correct. Again, this is only set, the motion on to compel by the plaintiff is set for March 18th. So there is no order ordering us to produce anything, and I just don't want to have that optics today before the court. I did confer with plaintiff's counsel last week, but I just want to also note today that we filed a motion for summary judgment in accordance with the court's standing docket control order that was ordering us to file a summary judgment, have it filed and heard by February 17th. Again, this case is 4 years old. We filed it timely. The court did not have an available date, so we filed a motion for leave to have it heard last week, which was the 18th, a day after the court order. We didn't have any choice, but also no discovery has been done up until then. And the plaintiff's counsel still, after I responded to discovery with objections, did nothing until after we filed the MSJ. So there was an inaction during this whole time until the MSJ was on file. And that's when I get hit with a motion for sanctions. Again, 4 years, the MSJ does not, there are 2 MSJs that we filed. It's a hybrid. Traditional can be filed at any time, and then we have no evidence. 4 years is enough time to gather evidence. It has to be adequate time. Discovery does not need to close, and discovery is closing next month, but it does not need to close for a no evidence motion to be filed. Adequate time for discovery, that's the standard. And if this time is not adequate, that I don't know that no case would ever fall or meet the standard. Also, plaintiff's counsel in their motion for continuance, they have not specified any evidence that are seeking that would create a fact issue. They are asking for topics, or they're listing categories such as corporate rep depositions, communications, compensation structures, policies, and vetting practices. But they're not telling us, and which they're obliged to tell us under Rule 166 AG, what specific facts are they seeking to obtain, and how will those facts would defeat the summary judgment that we filed. They are not identifying any communication where LOHI instructed the driver how to drive. They're not identifying any document where LOHI would dictate speed, braking, operational control, route decisions, anything like that. They are also not pointing to any record showing that LOHI knew or should have known that FNA was incompetent. And they are not pointing to any testimony as establishing operational control. They basically say, we hope something turns up, and that's not the rule. Secondly, even full discovery would not cure the legal defects. And let's assume for a moment that they receive everything that they have on their list. It still will not change the law. The policies does not equal control of steering and braking. The compensation does not equal control. The shipment communication does not equal operational control. Broker carrier contracts do not equal control over the injury producing conduct. And the injury producing conduct in this case is the driver decision to drive in dense fog at that intersection. There is no evidence that LOHI controlled that. And also under Werner versus Blake, a substantial factor test for causation, it requires responsibility for the conduct that actually caused the injury. And you cannot stretch it upstream into business relationship and stretch it into control. That's not the standard, that's not the law. This is just pure speculation on the plaintiff's part. And again, I already touched on the adequate time for discovery. Discovery does not need to be closed. It's adequate time. Even counting from just the remand, which occurred on May 1st, 2024, it's almost 2 years now. Deposition were noticed only after motion for summary judgment was filed. And unfortunately, Rule 166 AG, unfortunately for the plaintiff, does not reward inactivity in prosecuting their case. And again, a pending motion to compel does not create a fact issue. That is, and even assuming the court order all additional production tomorrow, they would still not be able to explain how that production would create a material fact issue. And Rule 166 requires more than just a possibility and a speculation. That's all I have at the moment. Thank you.
You have a response, Mr. Tani?
Yes. To begin, all these time delays, the reality is that they had initial disclosure rules to disclose relevant documents from the very beginning. And they did not file a motion for protective order until well after we filed our motion for our request for discovery, which was 6 months before the discovery deadline. So we spent 2 years in federal court trying to get the case back to state court. As soon as it got back to state court, they filed a motion to stay all discovery pending the Supreme Court's ruling on an issue that covers a broker liability. Once they lost that issue, we did send out discovery 6 months before, but it's been 6 months and they still haven't answered it. That's the problem. Now, we have, as the plaintiff, go ahead. Do you have a question, Your Honor?
Well, I'm just, okay, why have there not been responses to it? We're talking about the initial disclosures, right?
Correct. There's
Why
been
don't we have
there's
those?
been nothing but the insurance policies produced. That's it.
So that question is for you, Ms. Daniel. Why haven't we responded to those? And is that the subject of the motion to compel that's filed on the 18th of March?
That is the subject of the motion, so let's not confuse the issues in front of the court today. Secondly,
No, hold on a second. I'm not confused. As an aside, I'm asking if that's the subject of the motion to compel, but my question and my inquiry today is why there has not been a response.
a response to what?
Initial disclosures?
No, we just updated our disclosures on Monday this week. And we produced what we can produce. And again, my objections still stand to the discovery requests. So
Are
the
those
discovery,
objections consistent or the same objections that we heard back in December?
there were no objections being heard. There was no motion to compel. We only had a
No, but
confidentiality.
the basis of your request for a protective order that was heard back in December, right? Is it the same issue?
No, it's not. I have several objections, different bases for objections, and I'm not prepared to argue those, but that's in front of the court set for March 18th. And there are,
let me understand. So Mr. Tani has brought up the initial disclosures. Those were provided now on Monday?
the initial disclosures initially happened in federal court. And again, to correct the record, James just stated that the case was removed and pending in federal court for 2 years. That's not correct. It was removed for not even 4 months. And we issued initial disclosures under federal rules in 2024. We've updated them on Monday or supplemented.
Okay. All right.
The point is, Judge, is that these documents have to be disclosed under the rules. And so they just didn't disclose them. They still haven't disclosed them. So Monday, I got some documents for the first time, including full insurance policies I've never seen. Their only objection was motion for protective order and we conferred about this. I said, what is your objection to not producing these documents? Well, I need a protective order. Okay, well, the court already denied your entry of protective order. Well, it doesn't matter. I still need a protective order. So it puts me in a box, and that's why I'm here saying we can't really have this heard because for 6 months I've been waiting for these discovery responses. And so if the defendant is not going to listen to the court when the court says you don't need a protective order and force me to compel them, her response was to me, you need an order compelling me. Like there's no obligation or no duty under the discovery rules to answer discovery, that she needs a compelling order every single time to answer discovery. That's just not right. That's just not how discovery works. If your objection is addressed by the court, which it was, which is the protective order issue, you have to answer discovery.
May I briefly?
Yes, ma'am.
Again, the protective order was heard. We responded to discovery with objections separately. So our objections were never heard. So they're still in front of the court.
That is one thing that, so as we were talking about the protective order earlier, I pulled up the order December 8th, and the order is simple, and offhand, I don't remember the hearing in detail to know if we spoke or discussed specific objections. I don't recall ruling on those, Mr. Tani. The only ruling that I have memorialized in an order is the denial of the entry of the confidentiality and protective order.
Which is true, Your Honor. But when I conferred before we got here today, we conferred last week, the single and sole basis for not producing documents was the confidentiality agreement. This is the first time today she's saying she's relying upon other objections.
Okay, so what else on the motion for continuance? What is it that you're asking on the motion for continuance, other than just continuance? What are you asking, Mr. Tani?
Your Honor, we've taken the deposition of the driver. Okay, in the driver, I learned of a whole new potential party that again was not disclosed in the initial disclosure. So to give you some background, this company, F&A Transport, was basically a brand new company. Okay, and the way they worked is they worked through this app called 5F, and I had never heard of this app before the deposition a week and a half ago. Okay, come to find out, Low High and 5F which is a different company, have been working together for a while. Okay, and how do I know that? Because I've found online that they constantly sued together. Okay, they're constantly
what?
sued. They're constantly sued in the same litigation
sued.
all the time.
Mhm.
Okay, and so for example, let me show you here. Well, and you can even see on 5F's website, it talks about low high. And so there's been this third party, this potential third party that has not been disclosed to me this entire case. And why it matters is all the control is exercised through F5F. So what the driver said is that the the low high would give them the job through the 5F app. And the 5F app would actually provide an option for a route to drive, for the driver to drive through. These are all things, and I know this court has tried these broker claims before, but these things are all matter for exercising control. And as the court would remember, and you'll see here that there's other cases where there's been charges by employees of Low High Logistics doing business as 5F as joint employer. And other cases, including one in Las Cruces, where there's a lawyer, Brian Fisher, who's the defendant's partner in this case, who's has another case involving 5F. This case involves 5F as well. But as this court knows and remembers, there's two ways you can hold a broker liable. Okay, you can hold them liable for negligently selecting the motor carrier or exercising so much control over the load that they're no longer acting as a broker, and a broker can only arrange the transport of the load under the Federal Motor Carrier Safety Regulations. But if they exercise too much control over it, then they're them acting as a motor carrier, and they're subject to the rest of the Federal Motor Carrier Safety Regulations and would essentially be a statutory employer or an employer of the driver, therefore becoming vicariously liable for his acts and omissions. Okay. In this case, Your Honor, we'll start with the negligent selection argument. We've only taken the driver in this case because I don't have the documents to take the other witnesses. I don't have the documents to take the people from, I didn't even know about 5F until a week ago because they weren't properly disclosed. But I haven't taken anybody from Low High because I don't have the documents. I haven't taken the owner of F&A because I don't have the documents. We've gotten a report from our expert, and we've produced a report from our expert that meets creates an issue of fact as to Low High's liability, and I'm going to show you why. But when this court asked me, why do I need, what else am I arguing for motion continue? I need the documents to take the rest of the depositions. Without the documents, I cannot take complete depositions, because what will happen is what just happened on the last deposition. I found out about a whole party I never knew about, that defense's own firm knows about and has dealt with on other, and the Low High has dealt with on other cases that was not properly disclosed to me. And when I brought that up to the defense, they said to me, well, discovery is not closing. So I guess they intend to designate a responsible third party or potential party within the next 30 days or 3 weeks, even though discovery is about to close and the statute of limitations is passed. So I don't know what they intend to do, but that's what was mentioned to me. So going back to this case and the facts, as this court knows, there's often what we call broker carrier agreements. And in this case, there is such a broker carrier agreement, and that broker carrier agreement is issued between Low High, and I'll zoom in so you can see, and F&A Border Transport. Okay. Importantly, on this broker carrier agreement, there is a portion that talks about what kind of carriers and drivers they can hire. Okay, and what the requirement is. And so you see here under the requirement, this is the requirements of Low High in choosing a safe and competent motor carrier. They have to have been in business motor vehicle carrier transportations for more than the immediate prior 6 months. Okay, they need to can't have a safety rating conditional or unsatisfactory. They have to have a driver who has at least 23 years of age. They have to have a proper, complete driver qualification file. Okay, they have to have 2 years of verifiable commercial truck driving experience. Okay, So, and then they have all these extra requirements that are actually more than what's required by the Federal Motor Carrier Safety Regulations as far as moving violations. So this is what the standard is that LOHI has set forth to say, this is what we need from a safe and qualified driver. Okay, so if you look at this, you got to have a driver that's at least, let's start with the driver. If you're at least 23 years of age and 2 years of verifiable commercial truck driving experience. The driver in this case had his driver's license for 2 months, his CDL, his actual commercial driver's license for 2 months before this crash. He had never driven a commercial vehicle professionally before he got this job. He started this company with his mom. He was the guy in charge of safety. He testified he knew nothing about the Federal Motor Carrier Safety Regulations other than they exist. I even asked him what color the book was, which anybody who does any trucking work or in the trucking industry, what color the book is. He couldn't even tell me what color the book is. And this guy was in charge of safety for the company. He did not have a complete driver qualification file. He had not done a road test before this crash. He had not done anything required by the regulations. So a simple examination of this guy's driver's license by LOHI would have turned out that he did not meet the qualifications for their drivers. But more importantly, they'll probably come back and say, well, we weren't required to look at his driver's license of every driver. Well, that may be true or may not be true, but what they are required to do is look at the operating authority of the trucking company. And this is public information. So a lot of times you'll see in these cases, Judge, you'll see the broker say, well, we just looked at what was online and it said they were safe and they're fine, so we're good to go. Well, in this case, Judge, this shows here that they barely got operating authority 4 months before this crash. Okay, 4 months before this crash, and their own documents on how to select a safe and competent motor carrier requires that they have at least I think a year, I think is what I said, of operating authority. I can go back to the document, but this one had only had 4 months. So even a simple search online when they hired this company shows that they negligently selected per their own terms and own requirements a motor carrier that eventually lost its revocation, by the way. It was involuntarily revoked for having problems. Okay. This motor carrier did not even meet their own requirements. So the negligent selection portion of this case is solid, even on its face. Now, as far as exercising control over the load, they had this app that would tell the driver where to go, what directions to take. Now, of course, he could deviate from that if he wanted to, but it told him where to go. Then they had this 5F company that actually showed up to the scene of the crash after the crash. So for the first time, I learned that this 5F company exists, but not only did they exist, they sent somebody to the scene after the crash and was there while the investigation was taking place. So when I asked the driver, because this company is what we call a chameleon carrier, Your Honor. After this one, they set up 3 or 4 more trucking companies and they would get shut down by the government over and over and over again. Okay. And the guy even set up a broker company. So I asked him, because he's familiar with being a broker of load. I said, as a broker, who's somebody who's been a broker of a load and who's done all the paperwork and all the stuff under the Federal Motor Carrier Safety Regulations to set up a broker company that arranged transport, did LOHI do more than what a broker does when on this load for this case? And his answer was yes. Did they exercise control over you? Yes. Did they do more than just a broker does? Yes. So even a guy who's been a broker testified that LOHI was exercising more control than what a broker does. And so you understand the facts of this case, Judge. This guy that's been driving for 2 months, he pulls out in front of my client in the fog. When he testifies, he can see 2 to 3 feet. So he's coming up on an intersection. He can't see anything. He can see 2 to 3 feet into the fog, and he pulls out and kills my client, leaves behind a widow and his family. And so, Judge, we're here today to let me flesh this out. 6 months of waiting for discovery is insane. I've tried to work it out with defense counsel. We've not waste your time, Your Honor. This is a solid case. You can deny summary judgment now and have a clear record because We have enough facts. We have an expert affidavit I've attached to the summary judgment. I have the stuff that's clear as day on the Safer online. We have evidence of control that Ms. Abdul-Jabbar just supplemented our reply brief with a testimony from the driver.
So, Mr. Tani, let me interrupt you right there. So are you waiving your request to continue the hearing?
I think we need to continue it just so we can stay on track. I think the trial needs to be pushed so I can get the rest of the evidence, because what I'm concerned with is not the evidence as to the summary judgment for liability, but as to gross negligence. I need time to flesh that out.
Okay.
May I respond?
Yes, ma'am. Mhm.
Your Honor, one of the arguments that plaintiff's counsel made is that we are setting up to RTP an additional party. As the court well knows, this case is 4 years old. The accident happened over 4 years ago. All the statute of limitations, that all has long passed. It would not be possible to add an RTP or an additional potential party at this point. That's one comment that I have. Also, with regards to the broker carrier agreement that was produced by FNA in the beginning of July 2023 that James displayed sections for the court. There is an appendix A that he was showing, and I'm going to also share my screen and show. This is the FNA broker carrier agreement, and then there is an appendix to it, and it's a certification regarding driver qualification. This is not something that LOHI does. This is a certification by the motor carrier, which they, as a motor carrier, are certifying all these requirements. There is not another layer that LOHI goes and requests a DQ file from the motor carrier. They don't see their driver's license. This is a certification that the motor carrier is certifying that the requirements are met. So to argue that somehow LOHI does it, that's not LOHI. That's the motor carrier's responsibility to certify that they meet LOHI's requirements. And then again, with regards to negligent selection, that's something that is done at the time of selection of the motor carrier. So, and I think Mr. Tani wants to impose some hindsight, looking from today that LOHI should have done something extra. That's not the standard. That's at the time of selection, and that's per certification that the motor carrier issues. And it was certified to LOHI that these requirements have been met. Also, a plaintiff's expert cannot retroactively create some kind of notice. This is not a time machine. And those are the brief responses that I have, and I do not think that the motion for a continuance of the summary judgment needs to be granted. There has been plenty of time to conduct discovery, to conduct depositions. Nothing really has been done until the motion for summary judgment was filed per the DCO. Thank you.
Okay, so there's a few things here because I feel that this is kind of piecemealed out, and to add on top of it the new rules that cover my responsibilities for ruling on motions for summary judgment. Marissa, is the motion was filed when is our deadline on hearing the motion for summary judgment?
February 17th.
Was that the deadline to file?
The deadline to file and have it heard, set for a hearing, have it heard, and get a ruling. That's per DCO. We filed it timely with enough time for the 21-day notice, but the court did not have a hearing date until the 18th, which was one day late. So I filed a motion for leave to accommodate for that.
Sure, but let me see, is Marissa there? Maybe she's.
Yes, Your Honor. Sorry. So it was filed January 21st.
Mhm.
According to SB, it needed to be heard by March 1st.
So it's still, yeah, the window is still short. So with this new rule, so outside of the DCO, Ms. Danick, this new rule for courts is that, we have to rule on these. I'm not sure. I guess I'm not as familiar with the rule to know what it means when we have a motion for continuance. Am I still obligated because it's filed? It's not going to be withdrawn. I'm sure that I still have to rule on it by the 1st of March. I don't know. I don't know.
I don't, Judge, we're still trying to wrap our heads around that rule too. I don't know what it means.
Well, we tend to schedule things with the occasional trial hiccup and delay. Obviously, when things are being heard, we're usually hearing our summary judgment unless we hear from you all. So I'm inclined to grant the motion for continuance. With that said, I feel like I'm obligated to rule on it because it's not withdrawn before the 1st of March. It's still going to be pending. So, so with that understanding and the representation that plaintiffs have made today on your ability to respond to the motion for summary judgment, I just assume at this point, grant your motion. But with that said, I'm going to hear argument from Ms. Danick because I do feel like I'm still under an obligation to rule on the motion. With your response, Mr. Tani, I think you've made the record clear, and I clearly have an understanding of your position in being able to flesh out all the things you might present if we had had more discovery up until this point. Hold on a second. So, Ms. Danick, let me hear from you on the motion.
Well, with that said, I have to address additional things. Per the rules, the 21-day notice of a hearing, and then they have 7 days before the hearing to file their response to our MSJ, which they did so timely. And that's where the rule, as it stands now, ends. We filed a reply to the response 3 days before the scheduled hearing, which was set for the 18th last week, the 18th of February. However, then plaintiff's counsel filed 2 untimely without motion for leave replies, which are in violation of the rule for summary judgment. So I first would ask the court to not consider the 2 replies. One was filed the night before the 18th hearing, and one was filed yesterday. And they did not ask for leave. So I respectfully ask the court to not consider the replies that were filed untimely or not per the rules.
Were you going to say something, Mr. Tani?
Yeah, Judge, we just took a deposition and the transcript just came in. I mean, this is kind of crazy to me because she's put me in this position and now is trying to hold these rules over my head when she hasn't been following the rules of discovery the whole time. So we just got the transcript. So of course I'm going to present you with the evidence from the transcript.
So your request is denied, Miss Daniel. You may proceed.
With regards to the Lehigh MSJ, we do understand this is a tragic case, and no one is disputing that, but a tragic accident does not create legal duty for Lehigh, and it does not relieve plaintiffs of their burden to produce legally sufficient evidence. The question for the court today is narrow. have plaintiffs produced evidence that Lohi, a broker, retained control over the manner and means of the injury-producing conduct of the motor carrier, and was a substantial factor in causing the injury, this collision under the Texas law? And the answer, after 4 years of litigation, is no. So let me begin with control. And here Texas law is clear. The one who hires an independent contractor owes no duty unless it retains control over the manner and means of the injury-producing contact or activity. So the injury-producing activity here is the driver's operation of the tractor trailer in a dense fog. And the only relevant question to ask is, where is the evidence that Lohi retained the right to control how the driver operated the truck at the moment? And those things could be speed, braking, lane positioning, right-of-way judgment, and weather response. And plaintiffs have none of that. There is nothing. They do point to onboarding documents such as rate confirmations, communications, and compliance language, but those are brokerage functions. They're not operational control over driving. And if those routine brokerage activities that were created control, then every broker in Texas would be liable for every accident involving a contractor carrier. And Texas law does not impose strict liability on brokers. The second issue we touched on today is the negligent selection. And to avoid summary judgment, plaintiffs must produce evidence that Lohi knew or should have known that at the time of the selection, the carrier was incompetent. And notice is at the time of selection, and that's not hindsight. So the record reflects that the broker have complied with the certification process, had no disqualifying safety status or bad ratings. And plaintiff's argument is essentially that more vetting could have been done. But negligence law does not allow liability based on after-the-fact criticism, absent evidence of notice at the time of selection. And again, going back to the experts cannot retroactively create any notice. The third point is causation, and here we touch on Werner. And Werner makes it clear that proximate cause requires substantial factor responsibility, not just mere involvement, upstream logistics, but for reasoning or furnishing a condition. And for immediate producing cause was the driver's operation during dense fog. There is no evidence that Lohi directed, supervised, dispatched, or controlled that conduct. And I heard from Mr. Tawney about direction, and direction has two meanings, and or more meanings, but the two meanings we are plaintiffs' counsel seem to conflate is the meaning of direction as geographical direction and direction as giving instructions how to do things. And direction to geographic instructions where to go is not how to go. So that's the multi-meaning of the word direction. And here it was just basically where to go, not how to go, how to drive, what speed, how to turn, how to decide on weather conditions. Plaintiffs did, in one of the cert replies, I believe, attempt to analogize Lohi to the employer in Werner. Werner involved a motor carrier employer who trained, supervised, and dispatched the driver. Here, Lohi is a broker, and they did not employ the driver, train the driver, supervise the driver, or dispatch the driver. They did not control the manner of driving. Shipment coordination and rate confirmation are just broker functions, not operational control. And under Werner, there is no proximate cause as a matter of law. Now, briefly on gross negligence, plaintiffs do plead exemplary damages. Gross negligence requires extreme degree of risk and actual subjective awareness with conscious indifference. And there is no evidence that Lawhigh subjectively appreciated an extreme risk posed by the carrier and that they proceeded anyway. Without that subjective awareness, punitive damages fail as a matter of law. The last section or subject of the summary judgment is preemption. And independently, the negligence selection claim is preempted under the federal regulations or federal rules. And the statute prohibits state laws related to broker services. Selecting a motor carrier is the broker's core service. The claim seeks to regulate how a broker performs the service. And plaintiffs here invoked the safety exception. However, the safety exception preserves regulations with respect to motor vehicles. It does not convert every crash into a motor vehicle regulation case. The claim regulates broker decision-making, but not how the truck is driven. And if every crash automatically triggered the safety exception, the broker preemption clause would be totally meaningless. Briefly on the Miller case, which plaintiff seems to rely on, that's not binding in Texas. This is a Ninth Circuit case, and we're in Fifth Circuit here, where there is a split. But even if the court declines to reach preemption, plaintiff still failed on Texas tort elements. And the case comes back to the three issues, the three pillars, which is operational control, causation, no substantial factor causation, no evidence of operational control, and no evidence of gross negligence. And after 4 years of litigation, plaintiffs cannot identify evidence that Lawhigh controlled manner and means of driving or was responsible for the injury-producing contact. And again, going back, even assuming that we were ordered to produce these documents tomorrow, they still would not meet the standard. Therefore, under Rule 166A and Werner, Lawhigh is entitled to a summary judgment at this time. Thank you.
Thank you, Ms. Danek. Mr. Tani, do you have a response?
Yes. As I mentioned earlier, there's two ways of holding a broker liable. And we talked about the negligence selection. I'm going to start there. Again, operating authority issued in September 30th of 2021. Guy gets a CDL on November 22nd, 2021. They buy the truck in December. So we know that he is not even driving before December. Crash happens in January. Okay, so this is the course of events in this case. Okay, company had no safety program. Driver did not have a complete driver qualification file. They didn't even know what the motor carrier safety regulations books look like. No post-crash drug accident or alcohol test within a timely manner after the crash. The operating authority was eventually revoked involuntarily by the Federal Motor Carrier Safety Administration. Lawhigh brokers a load to them through a company called 5F. 5F is basically just an app where frac sand carriers can sign up and get a load and move frac sand in the oil field. This is a negligence section case that they use against Lawhigh because they use 5F to control and to hire negligently this F&A transport. We submit, in addition to what I mentioned earlier, Judge, we submitted a affidavit incorporating our expert, Brian Riker, who is an expert in transportation safety, his report in this matter, which we incorporated for hearsay purposes via an affidavit. And he talks about this. He talks about that although public records indicate that FNA came to existence based upon a registration for a US DOT number sometime in February 2020, they did not have active operating authority until at least 18 months later, nor did they have any roadside inspections recorded until February 2022, which is after our crash. The data included in the safety management system, this is important, Judge. So any broker can go, and anybody, even you, Judge, can go onto the internet and look up the safety management system for any motor carrier. And what that does is it gives you information about the company, how long they've been operating, how many times they've been inspected, how many times they've been put out of service for either driver problems or vehicle problems. All the broker had to do when selecting, and they have a duty to select properly under the restatement, second 411. Okay, you can't just say, I'm going to pick somebody and wash my hands of it. Under the restatement, there's a duty to select safely. That's why they're called negligent selection theories, because you can be negligent in selecting a broker and selecting a motor carrier. The broker can't. That's the whole basis of the argument. Well, they could have simply gone to the safety management system, which is what most brokers do, as per Mr. Riker, our expert, and they look to see what kind of activity this carrier has had. Well, if they would have done it on this case, they would have seen there's no activity because the carrier had not been in existence, had not been driving. And even though it violated their policy, they still entered into an agreement to allow this driver to move frac sand. And so they will check. Freight brokers will often check to make sure there's been a roadside inspection, making sure the equipment is safe and that they're complying with the Federal Motor Carrier Safety Regulations. But they didn't do that here, or if they did, they ignored it. They would have shown, if they would have checked the safety management system, that FNA had little, if any, experience as a motor carrier. So we see that, again, the operating authority started in September 24, 2021, and that violated all the policies regarding operating authority that LOHI had. In addition, there's more, as our expert sets forth in his report, there's more control over exercise over FNA by LOHI through their agreement, their broker carrier agreement, and their master transportation their transportation agreement. This case is more than just a negligent selection case. It is an exercising of control case. And as we set forth in the response, the supplement to the SIR reply, because we just got the transcript, and I'll show it to you here. I can show you the testimony from, and you should have this, Judge. We had it delivered late yesterday, but you'll see here, I asked the driver, I said, when you're doing this work in the oil field, moving this sand frac, which is a very important job, the people that were telling you where to go, where to show up, what time to be there, when to drop things off, when you had a problem with the app, all that came from 5F. 5F is how LOHI communicated with FNA Transport. Okay. I said, you were taking no directions from your mom because the mom owned the company. Okay. It was the mom and the son. Son was in charge of safety. Mom was back in the office. She didn't have a CDL. She didn't know anything about truck driving. She was just opened the company with her son. Okay. You were taking no direction from your mom. You weren't getting dispatched by your mom. You weren't taking any driving routes from your mom. You weren't taking any kind of load instructions from your mom. It was all coming from LOHI through 5F. Isn't that true? To my knowledge, yes. I mean, that is the control. That creates a fact issue as to control on its face, Your Honor. And as I mentioned earlier, Defendant Sanchez, the driver, said even himself that LOHI was doing more than a broker would do, as he had experience as a broker. But in addition to the information we talked about before, I want to address a couple more things. The FAA preemption issue, that has already been ruled on by Judge Cardone. That has been ruled on by this court when you did not stay the case. This has been ruled on by many courts in the Western District, including courts across Texas. It is true that there's a split, but this issue has already been ruled on multiple times, Your Honor. I'm sure this issue came up in your last case that went to trial with Mr. White, and I think it was Mr. Rincon, if I recall correctly. This is an issue that the negligent selection issue is up at the US Supreme Court right now, but the exercise and control is not. With the FAA preemption issue, no Fifth Circuit court has held that these claims are preempted. Okay, none of them. Okay, these claims are valid. These claims are being filed across the state of Texas. And this is, again, has already been ruled upon by Judge Cardone, in which she wrote a lengthy opinion. I can bore you with the intricacies of the Miller case and the Yee case and the Aspen case, but simply put, this issue has been addressed already. Finally, on the Warner case, I want to talk about the Warner case because it's kind of the language in the Warner case is being cherry picked. We as trucking lawyers watch this Warner case very carefully, and I want to make sure you understand what happened in the Warner case, Judge. What happened in the Warner case is a family was driving through the snow, okay, and it was really, really bad weather. They were headed one way on the freeway, and on the other side of the freeway, there was a truck driver driving a truck. The family lost control going one direction. They went through the median, went into oncoming traffic, and the truck hit the family and killed them. Okay. In that case, the Supreme Court bench, Texas Supreme Court eventually held that the duty and the causation was because the family lost control and went in front of this truck, and that's what the problem was. And they said the claim against the trucking company was not valid there because did not meet the causation standard there because he maybe should not have been on the road per the Federal Motor Carrier Safety Regulation, or he should have got off the road sooner per the CDL manual because the weather was bad. The real cause of that crash, according to Texas Supreme Court, was that a car lost control and ended up in front of the truck. That is nothing like what we're talking about here. What we're talking about here is LOHI allowing and doing business and negligently selecting, negligently controlling a unsafe motor carrier that doesn't meet any of the requirements of the Federal Motor Carrier Safety Regulations, has nothing in place, no safety program in place, only been in existence for a month and a half with the truck, putting them out on the road with a driver with no experience, and because he has no experience, because this company has no safety, because they're doing this thing, they're getting paid a buck. LOHI is making money off them, but is now trying to wash their hands when they have this business practice of hiring these kind of companies to put them on the road that killed my client and her family. That's, Your Honor. There's a fact issue for the courts to hear. There's a fact issue on summary judgment because they know these things are not safe. So we want to talk about subjective awareness. They know that the trucking companies like this are not safe because they make you certify to that. The broker carrier agreement makes you certify you have all these requirements because they know it's unsafe to hire a trucking company that does not have these requirements. So therefore, you can't run away from the subjective knowledge. They showed the subjective knowledge in the broker carrier agreement, and they disobeyed it. They disobeyed it at the risk of the public, and that subjective awareness and the objective danger to the public means you should deny this summary judgment on all grounds, Your Honor, because there's a fact issue for the court to consider. Not for the jury to consider, sorry.
May I briefly?
Yes, ma'am.
Well, one thing is, it seems like Mr. Tawny is arguing in MSJ that he has not filed against FNA. This is very simple. Plaintiff must show notice of incompetence of the motor carrier, but there is not such thing. They're not going to be able to show it. They cannot show it. It doesn't exist. There is no notice of incompetence at the time of selection. There was none. There isn't one. They can't point to it, and that's the standard. They cannot show it. That doesn't exist. The notice, it was decertification by FNA, and plaintiff's argument that additional vetting could have been done, it's just not the standard. The standard is plaintiff must show a notice of incompetence at the time of selection. And Mr. Tawny's mudding the water with saying that they didn't have any safety protocols. That's not on LOHI. That is an argument he could have made, but he missed the deadline and file an MSJ against FNA. That's not something to blame LOHI for. Again, LOHI had the requirements, had a protocol, had a written certification that it obtained from FNA, and that was all. And there was no notice of incompetence at the time of selection. And that's all I have. Thank you.
Thank you very much. Okay, so the motion for summary judgment, the court will take it under advisement at this time. I'm really not sure how to reconcile the court's obligations under this deadline to rule on motions for summary judgment and your motion for continuance. So with that, the court will have a ruling before the 1st of March on the motion for summary judgment. That said, then I think the only thing we had left was the bifurcation, but that was, let me pull that one up. Defendant's joint motion for bifurcation.
Your Honor,
We don't oppose that, Judge.
Right.
I don't think we have
Okay.
grounds to oppose that.
Right, so we need an order. I'll need an order on the bifurcation that is obviously granted. So if you'll get me the proposed order, you might have sent it, frankly. I know I have received so many things that it might be simpler if you just shoot it over. And you might as well send over a proposed order on the motion for summary judgment while you're at it. Okay?
Sounds good. Yes, I have an Excel spreadsheet for all these motions because
good
I
for
couldn't.
Mr. Tani, let me have the order on the motion for continuance. I know that it seems really weird, but it was granted. Your motion for continuance was granted. I just wanted
Okay.
the opportunity to hear your arguments on this in light of the deadline for the court. Now, with that said, we still have some scheduling matters. Frankly, this is, I hope I am not ignoring the details, so to speak, but I have a list, and maybe Ms. Danick, with your spreadsheet, you can cross-check me on this. But frankly, with everything that is outstanding, and I think with the potential that so many of these issues are kind of intertwined, I really just want to pick a day. I just want to pick a day when, and on the, the motion to compel is set for March 18th. I
Right.
don't want to wait that long, but I know that's what we told you. So if I can find a day, and I don't necessarily mean all day, but probably half a day, where we can set, let me see what I have. Well, let's see, I have a list. No. Wait a minute.
Judge, I can probably make this much easier. If I will withdraw this motion for sanctions if the court just says, makes a ruling on this protective order issue. If Miss Doniak has other issues that she's not producing the discovery for, I will go back to her and talk to her and work those out as far as relevance and other objections like that. But if it's
what
just
I
purely the
understand-
protective order.
Yeah, but what I understand though is that, and maybe correct me if I'm misunderstanding Ms. Danick, is that Ms. Danick, at least in what you're representing, you all have discussed, is asking for a ruling on a motion to compel.
Well, I'm not prepared to argue it. It's lengthy.
No, I know.
Yeah.
I understand that, but I don't know just the protective order issue if that's it.
There is not, it's not it. There is more, and I literally put it to rest, and I started drafting a response, but I was going one by one. So I don't. There are other objections, but also I spoke to James on Thursday, I believe, and I asked him, for some of the things, some of the documents, we would love to produce it, as soon as possible, really, because I know I want to have this case moving. There's already been 3 continuances of the trial date. So I know we, might be facing another one, short reset, but I want to move this case. But there are some documents that are confidential and trade secret in nature. And so if I can have some narrow protection to produce these, and I want to produce them, I'm not withholding anything. I just need some protection for my client. It's a competitive business, and I just don't want these documents to be out in the public, but it's not redacting anything, and it's going to be produced, just marked confidential, so it's not disseminated. But there are other objections which I can't recite right now.
Well, maybe if she produces me a privilege log, but she has not
There is
done.
no privilege log because I'm not withholding anything, James. I literally want just a few. It's not gonna even be voluminous. Some of them would just be marked confidential, subject to some protection, so it's not disseminated. That's all I'm asking for. And I've been willing to do this from the beginning. And our discussions did not go well, but I'm still open to communication. I think that solves a lot of issues.
I think a privilege log saying what you think should be entitled to trade secret protection would help me understand what you're holding on to, because I don't know.
Okay, I mean, I'm gonna try to maybe, I mean, it's again, don't expect anything voluminous. I think, it's you're gonna get the production, but there are gonna be several documents that would be marked confidential, and I can get you a list. What's today's Wednesday? By if I can have a week to do that. Would
Judge,
that be
I would
okay?
suggest just leave the March day, and I will work with Ms. Danya to get this figured out. I just need to see what there is.
Okay, hold on. The other complication I have is that is kind of set. As I said, you all special today at 8 a.m. and I got my 9 a.m. folks waiting because I wanted to make sure we had some time together. I feel like for the next setting, it's going to be the same thing. And you are set on March 18th, which is part of my regular, no offense to the whole home docket, but the regular docket, civil docket. So what I would like to do is move the March 18th hearing to March 16th, which is a Monday at 8:30 a.m. You can't do it, Ms.
I'm
Daniel?
gonna be on a plane. I'm actually, I believe I have a vacation letter. I was gonna attend, but I'm gonna be flying on March 16th.
When does that unavailability, what's the start end on that?
The pretty much the full day. I'm still, I know with the violence in Mexico, but I'm going to Mexico.
So I asked that because we could do the 12th in the afternoon.
The 12th,
Am I looking at the right month? Yes. Yes. And Marissa, I'll rely on you. Let me
that
see.
works for me. The 12th would work for us.
Same for plaintiff, Your Honor.
Oh. The only problem is we will have to be, because we do have a Zoom docket that afternoon on the criminal side. So I think we can just be in a special room. So we can have a breakout room, I think, Mr. Nanez, Ms. Nieto, on March 12th at 1:30. And while my staff takes care of the criminal stuff on Zoom, we'll be in our own room with our motions. Now, on my little list, I don't know if mine conformed as much as I thought with Ms. Nieto's list. I'm showing that will be the motion to compel discovery
Mhm.
that was set for the 18th, will now be on the 12th. I have a defendant's motion for leave to file cross designations. Does that need a hearing? Yes, you requested a hearing on the 28th. Is that right?
That's just cross-designating expert that FNA has. So
For leave. Then I have a defendant's motion, Lohai's motion for application of foreign law. These are the motions for which we have received requests for hearing. And then defendant's motion to compel mediation. And then, of course, plaintiff's motion for sanctions. Let me see. In my little chicken scratch, I think I still have a plaintiff's motion in limine
Yeah, just for the police officer.
yes.
for the report, and then Motion to strike expert witness affidavit. I don't know if that applied to this hearing. I didn't go through. I was just.
Yeah, I filed that against her expert as to the foreign law issue.
Okay, so then
Mhm.
that one sounds like a live one also. Is there anything outside of that? I mean, I want to take advantage of that date. I'll say it like this. In light of the April trial setting, but frankly, I think each of you has begrudgingly alluded to it. I don't know how realistic that April 17th trial setting is. In fact, I feel like even understating, I feel like I'm understating it by saying it like that. I don't think we make the 17th, period, but I'm sure you all have opinions on that.
And we have for the 18th of March, we also have the final pre-trial, so that goes into the trial setting.
Right. We can put everything on the 12th, frankly. I just want to get all of these contested, maybe not so contested, but contested issues resolved so that I know where we are for April 17th.
Yeah, so because we also have to exchange witness lists, all that pre-trial fun. I don't know if we're gonna be able to meet the deadline for the 12th.
I'm happy to leave the final civil pretrial for the 18th, but all of these things that are contested and require hearing will be heard on the 12th.
That sounds good. That works for us.
Can
And
you
hopefully me and James can work out a bunch of things.
Can you all get to the court by 2:25 by March 4th?
I'm not,
Hold on a second. An agreed list of things to be heard on the 12th? So
Yes,
like
Your Honor.
if you tell me like I don't want to rely on my list because I just think
Yeah.
you all know what you all are doing and what we still have outstanding. Can you let the court know by email by March 4th? And that will be whatever is not agreed on is going to be set on the 12th. What is agreed on is still outstanding will be heard, and what has been agreed to and no longer needs to be heard, that's going to be great, and we'll memorialize that on the 12th, and it won't be heard. But we're going to clean all of this up because I think there's just a lot outstanding. And just know for the 12th, anything that gets filed after yesterday, we're not doing that on the 12th. Okay, we're just going to catch all that has been filed up until now.
Sounds
Yes,
good.
Your Honor.
Sounds
That
good.
makes sense? Yeah.
Yep.
Okay, good. Anything else for today?
Thank you for your time, Judge. That's from the plaintiff.
No, thank you guys. I felt really bad. That's why, believe me, I don't love 8 o'clock, but you needed it. So
Well, thank you, Your Honor. Thank you for your time and
absolutely. We'll see you
patience.
all on the 12th, but I know I'll hear from you. The 12th is at 1:30, Marissa, 1:30 p.m. via Zoom. Is anyone asking for in-person?
I'm not.
No, we're not.
Okay. Okay, so 1:30 on March 12th. The March 18th setting will now only include the final civil pretrial. Okay,
Thank you. And that's by Zoom too, correct?
all by Zoom. If
Okay,
that's what you're
sounds
asking.
good. Yeah, I'll be in Mexico, hopefully. Okay. Thank you.
Thank you all.
Thank
Y'all are
you.
excused.
Thank you, Judge.
Let's
you.
take a quick break, just like 5 minutes before we get to the remainder of the docket.
Yes, ma'am.
Thank you.
Alexa.
Gary. All right. Hi, Miss Sotelo. Are you there?
Good morning. Yes, I'm here.
Hi, what case are you here for? Can you have the last four of your cause number?
Yes, it's 2160. 2160.
2160.
Oh no, I'm so sorry. My bad. It's 1731. I'm so sorry for that.
That's okay. Okay, you're here with Miss Dodson?
I am local counsel. I think Miss Dotson is from the actual law firm handling the case.
Okay.
That is correct. I'm in-house counsel.
Ms. Dodson, this is on 1731. Are both of you here on 1731?
Yes.
That's what it appears, Your Honor.
Okay, so I had this down just to check on mediation.
So we reached out to the mediator to get available dates and followed up again with the most recent contact being this morning, and he reported that he had not heard back from the defendant on scheduling.
And Your Honor, if I may add, I did speak with another attorney as well, and she let me know that apparently the defendant has not answered. She was served on June 10th. She hasn't answered, and also a motion for default judgment had been filed in July last year, July 23rd.
Here last time by any chance? Trying to think. Let me pull up the case. So we had subservice, right?
Yes, Your Honor.
And then no answer is what you're telling me. That was back in June.
Yes, Your Honor. And then the default motion was filed on July 23rd.
So do we I'd have to go back to like my handwritten notes. But I feel like in December, well, did she appear?
As for that attorney, I don't think there's any record of her appearing or anything.
No, Your Honor.
Oh, maybe I'm trying to figure out why I would have ordered you to mediation unless I had seen the defendant.
Judge,
Wow.
if I may, on those requests for final trial settings, they are requesting for a bench trial. I do not remember if she appeared either,
Oh.
but I believe, like, based on what they were filing, that she must have appeared somehow, some way.
Yeah, it seems like we should have had the motion for default judgment set. Right?
That's what we are hoping for. Yes, Your Honor.
I'm looking in the file, Your Honor, and I have no idea why we filed a motion for default judgment followed by a request for final trial setting. I do not know, but I don't see any indication that the defendant answered.
Right. So let's do, I think, what should have happened if there had been a request. I don't know, maybe there wasn't a request. Are you asking for your motion to be heard?
Yes, Your Honor.
So we'll set that in 30 days. 30 days will be March 25th. March
That
25th
works.
at 10 a.m.
Okay.
So what I need is for a notice to go out to Miss James with that date and time, with the Zoom information, and to have that proof of service, preferably certified, something that is presentable to show the outcome of the notice in time for that hearing. Okay?
Thank you, Your Honor.
Thank you very much. Have a good day.
Thank you.
Thank
All right.
you. Thank you, Your Honor. May I be excused?
Yes, ma'am. Have a good day, guys.
You too.
All right, now we can get started. Where are we going, Mr. Nunez? If you're talking, you're muted.
I'm sorry, Judge. Next one's not till 9:45, and I don't see anyone here from Mr. Mendez or Mr. Gagnon's office.
So that one is still set for scheduling conference. Do we have a scheduling order? I know we got the order on the motion to abate and compel. I think they forwarded that and I signed it this morning, but it is still set for a scheduling conference, right? Marissa, we haven't already received a scheduling order, have we? Have we given them a trial date?
I'm sorry, I was on mute too. No, Your Honor.
Okay. So let's give them a call. What trial are we looking at? What trial date are we looking at? Are we looking at February of 2027, or what date are we looking at, Marissa?
February 12th of 2027.
Okay.
And then after that, it would be April 16th of 2027.
Okay. Thank you. All right. So we'll wait for them. And also then we don't have anything, but who's here? Mr. Flores, 3936. That I signed the non-suit this morning on Crystal Garcia and Juan Jose Galvan. Is that what you're here on?
Your Honor, no. Unfortunately, I'm from Jamie Hans, the plaintiff's attorney for Jamie Hans, cause number 2025 DCV 4775.
Okay, so we need to change your name on there. It says you're Renee Flores and you're 3936.
There might be another Rene Flores.
Let me see. The cause number, what are the last ones?
4775.
That's set at 10:30.
Yes.
That's dismissal hearing. And you're here
Yes.
on whose?
On behalf of yes, in behalf of the plaintiff, Jamie Hans.
Okay. That was set for dismissal. I don't know if anybody else is here. Okay, so that changed. Okay. Miss Jacobs on 2025. Let's find that one. That one's set at 10. Miss Jacobs, who do you represent?
I represent TA Operating LLC, and it just occurred to me that I'm in Dallas, that I'm in a different time zone. So
Same.
That just occurred to me. So is it okay if I just mute and
That's fine.
take my video off and stay on till 10?
Mm-hmm.
All right.
And then 45, 42. Mr. Morales, you're also here on 45, 42. That's at 9:45. And then we're missing, I think, someone from Miss Labinotti's office, Miss Payne and Mr. Morales. Okay, we'll be with you shortly. Mr. Mendez, we're just waiting on opposing counsel. We just have the scheduling status conference for today. I think I signed the proposed order on the motion to abate. So I think we're just waiting for Mr. I think I say his name wrong all the time, Mr. Gagnon.
Mr. Gagnon is logging on, Judge.
Okay, okay. We'll take care of that quickly. We have trial dates either February 12th, 27 or April 16th. There he is. Good morning, gentlemen. Thank you for logging in so quickly. Let me go ahead and call the case. I know we're a little bit ahead of time, but it's just a scheduling conference. This is cause number 2025 DCV 3807, Jesus Arturo Nevares versus Encino Metals et al. May I have announcements, please?
Morning, Your Honor. Oscar Vince on behalf of the plaintiff.
Joseph Gagnon for the defendants.
Good morning. We are set today for a scheduling status conference. Are you all ready for a trial setting?
Yes, Your Honor.
The defendants would say no. We would disagree with that.
Okay. So what are you wanting to do other than get a trial set?
Well, we haven't conducted any discovery. The matter is in its infancy, so that's my only concern. I guess it depends on what we're talking about as far as the trial setting goes. If this is something that we're talking near term.
Scheduling status conference is I give you a trial date and you all circulate a scheduling order with all the deadlines that will apply to the case, including settings. And so the court has February 12th, 2027 or April 16th, 2027. Then from there, we'll send you the scheduling order. You all fill it out, agree to a mediator, send it back to the court, and you'll have your dates.
I understand. Okay.
Is there any problem with either of those dates? If not, I'll go with the February date.
I would. I think the April would be better for our schedule over here, Your Honor.
Mr. Gagnon, anything wrong with April 16th?
No, if that's better for counsel, then the April setting would be fine.
So we're going to go ahead and do that. We'll get you the scheduling order. Please circulate it, agree on a mediator, include that on the order. You'll see a setting in 2 weeks for entry of that scheduling order. If we have not received the agreed to scheduling order, then you need to appear. Other than that, you will have your dates. Anything outside of those dates, if you need a hearing, please make your request with the court. Okay?
Thank you, Your Honor.
Thank you very much. You all are excused.
You.
Have a good day.
You too.
Okay.
Hello, sir. Why are you here? Unmute so I can talk to you. Hello, sir. Why are you here? Mr. Gonzalez?
Yes, sir. Can you hear me?
Yes, I can. Why are you here?
Yes, sir.
Yes, this is David Morales.
Yes, sir. Thank you, sir. Judge will see you shortly, Mr. Morales. Mr. Gonzalez, why are you here?
Yes, sir.
Yes, why are you here, sir?
Why am I here?
Yes, why?
I was here because I was told to come by.
You have a case today, sir?
Sir,
Yeah, it was a
he's a defendant in the a co-defendant of Ms. Lucas. I think the case is Lisbeth versus is this Mr. Gonzalez, right?
Yes, sir.
And my client is
Okay,
Ms.
he's
Lucas.
on this case then? Okay. Mr. Gonzalez, I'm gonna put you in the waiting room. Do not leave. I'm gonna let you in when it starts, okay?
Okay.
Thank you very much, Mr. Morales.
I think, is everyone here on that case, 4542?
Yes, ma'am. Let me. Yes,
So,
ma'am.
Mr. Morales, is that your client?
No, Your Honor, my client is Rachel Lucas. I'm not sure who represents Mr. Gonzalez.
Okay, let me look at that real quick.
Honor, this is Miss Payne. I just want to say that I represent the school district and Miss Miles, but not Mr. Gonzalez.
Okay, let's go ahead and bring in Mr. Gonzalez then. What is this petition? All right. Good morning, Mr. Gonzalez. I heard, this is Judge Perez. I heard your interaction. We're about to call the case that I believe you are a defendant on as well. There are several defendants. Okay. So are you not represented by an attorney? And I'll have to ask you to unmute.
No, ma'am.
Okay. Okay. So is everyone ready?
Yes, Your Honor.
Calling
Yes,
cause,
Your Honor.
calling cause number 2025 DCV 4542. Lisbeth Idali Terrazas Mian. And well, I don't know. We have some interveners. There's a petition and intervention on Kevin Arredondo and Alyssa Arredondo versus EPISD, El Paso Independent School District, Rachel Ann Lucas, David Steven Gonzalez, and Christine Miles. May I have announcements, please?
Good morning, Your Honor. Omar Silva for the plaintiff, ready?
David Morales for Rachel Lucas, ready?
Your Honor, Katie Payne on behalf of the school district and Christine Miles, ready?
Also appearing, would you state your name for the record, please, sir? Mr. Gonzalez?
Oh, yes, ma'am. David Gonzalez.
And Mr. Gonzalez, I think I was asking you off the record, but you are not represented by counsel. You're a self-represented defendant in this case?
Yes, ma'am.
Okay, we are scheduled today. This, I believe, was a case that was transferred from County Court 6 here back in January. So with the exception of the petition and intervention, the court is not that familiar with this case. However, we are set for scheduling status conference, which everyone understands is just our initial start date, where I give you all a trial setting down the road, and we get a scheduling order in place that will govern all the deadlines, future settings, future hearings. I also require that we have an agreed to mediator included on that order. For those of you who practiced in here before, it's a standard order. You all are welcome to create one on your own, as long as it includes all the deadlines and the mediator, and return it to the court, agreed to by everyone. The entry of that order will be in 2 weeks. And so who wants to tell me? Let's start with you, Mr. Silva. Where are we on this case? I mean, you all, I guess, had just started in CC6 as well.
Yes, Your Honor. There was motion to dismiss, motion to quash. We amended the petition, and then there was a petition for the intervention, and then it was transferred over here. So now that it's transferred over here, we're going to be reaching out to defense counsels and start going through discovery, but that's where we're at.
So is the petition and intervention the only thing that was outstanding coming from CC6, or is there anything outstanding? Because I see the in terms of the timetable, notice of dismissal hearing, and then the amended petition. Yeah, I don't see any.
Your Honor, I believe we filed Rule 91 motions to dismiss, and then there was a petition and intervention that's been filed.
So yeah, so then the motions to dismiss were not heard, right?
They have not been, correct?
Okay. So let's start with the scheduling order. The scheduling order, I am looking at, what is the date? February. We generally go a year out. So right now we're at February 12th, 2027. The next one I have after that is April 16th, 2027 as a trial date. And then, of course, all the deadlines and hearings, we will have interim settings before that trial date. Is there any preference on either of those two dates?
Your Honor, I think April would work better for us to handle all the motions to dismiss hearings and then go through discovery, depositions, and mediation after I believe, the motions to dismiss hearings. That gives us enough time.
I don't have a problem with that. We can do April 2027.
I'm sorry, Your Honor, did you say April 16th, 2027?
Yes, ma'am.
Thank you. Sorry, I'm checking both my calendar and the school district's calendar, so that's why it's taking me a minute.
That's okay.
No objection to April 16th from the school district and Ms. Miles, Your Honor.
And what happened to Mr. Morales? Yeah, we lost Mr. Morales. Well, we're waiting on Mr. Morales to see if he logs back in. Mr. Gonzalez,
Yes, ma'am.
the court, because this is our first setting, we'll put in a scheduling order in place that it has pertinent deadlines and subsequent hearings. There's Mr. Morales. But so far, plaintiff and the school district are in agreement with a trial setting of April 16, 2027. Do you have any issue with that date?
No, ma'am.
Mr. Morales, are you still there? Mr. Morales?
Can you hear me?
Yes, we lost you
Okay.
there for a second. I was
Yeah, we did.
discussing a trial setting. We are looking at April 16th, 2027.
Yes, Your Honor, that's good.
Okay, so that's going to be the trial setting. It's going to be April 16th. What will happen is we will provide you a scheduling order. If I already said this, please
Thank you.
disregard. But if you all want to generate a scheduling order that mirrors the court scheduling order to include an agreed to mediator by all parties, and then everyone has to sign off on it in agreement. If not, then there will be a hearing 2 weeks from now at 3 p.m. on Zoom. Everything is on Zoom unless the court orders otherwise, and the Zoom ID login is the same one as today. So we'll get you the scheduling order with that trial date, pick your mediator. If everyone's in agreement, then I won't see you in 2 weeks. But if we're not, if I don't have a signed off on by everyone order, then you all will need to appear at the entry hearing. Does anyone have any questions?
Your Honor, the motion to intervene.
So if you're asking for a hearing on that, I need you to, if you haven't already done so, email the court. Ms. Marisa Nieto is the court coordinator. Please email her with your pleading and your request for hearing, and we will get it set.
Okay, Your Honor, thank you.
I'm
Same
sorry, Your Honor, could you say that person's name one more time?
Marisa Nieto, so her email is ma.nieto@epcountytx.gov, I think, gov. Yeah, it's in the chat. If you have any questions, feel free to call the court. The same process for anything that needs a hearing that doesn't already coincide with a date that is prescribed by the court, pre-ordered. So any request for hearing on things that have been filed, you email Ms. Nieto and make the request with your filed pleading, and we'll get you set.
Thank you, Your Honor.
Any questions?
No, Your Honor.
Mr. Gonzalez or Mr. Morales, any questions?
Yes, ma'am. I mean, so I'm reading the letter, and it's stating like something about a dismissal. So I mean, where do I stand with this, or I'm just not sure what's going on. I'm sorry.
So it appears, I don't know if, are you referring to the district clerk's letter dated December 19th, or what are you referring to, Mr. Gonzalez?
Yes, ma'am. Well, I'm just referring to the letter that I'm reading.
That says what?
I'm so sorry. I'm just something about a dismissal. I'm just not really sure why I'm here or what's going on exactly.
So you're a defendant in this lawsuit? Have you, I mean, you received notice about today's hearing, maybe previous hearings? You were served with a lawsuit, is that right?
Yes, ma'am. And I actually logged in a couple of weeks ago, and they claimed that I was in. I had logged in at the wrong time or something, but I'm just not sure what's going on, Your Honor. I'm just not sure.
You've been sued, right?
Yes, ma'am.
And you received a copy of the lawsuit?
Yes, ma'am.
Okay. And I'm not sure what letter you're referring to. Just in me looking at the entries of events on this case, I do see this case was in a different court, in County Court 6, and it was transferred to this court. This is the 210th District Court. I think after possibly the letter you're telling me about, I'm not sure. Does your letter have a date on it, and does it say who it's from?
December 19th, 2025. You are hereby notified that a dismissal for want of prosecution hearing has been set via Zoom in the above styled a numbered cause at 10 a.m. on 2/17/2026 in the county court at number law 6. Please see the attached order for further instructions.
So that is what I'm seeing, and that predates what I believe is the transfer. So the case was that I can tell was set for a dismissal hearing in county court at law number 6. That case is now in my court. I can only deduce without going back into the events that it was not dismissed because I got it. Now, normally dismissals for want of prosecution or because cases are inactive, but I don't know what happened in CC6, the other court. What is happening here is I'm setting a trial track for this case. So you are a party. You have been sued by the plaintiffs in this case. You're one of a few defendants. And as you're sitting here today, I understand you are not represented by an attorney and you are representing yourself. If that changes, if you hire counsel, then I expect I will have an entry of appearance by an attorney on your behalf. So what we are doing today is basically getting the case scheduling set. So that's why I was discussing a trial setting in April of 2027. I believe it's April 16th. So that was the purpose of today's hearing, was to get the scheduling order in place that will govern settings and deadlines in this case.
Your Honor,
Hold on, Mr. Morales. Mr. Gonzalez, did you have any other questions or anything else I could clarify for you?
Yes, ma'am. I'm just not really sure as far as okay, so my understanding was everything was going to be dismissed, but now you're telling me I'm going to have to come back?
That's correct. I don't know if the parties have any information about what happened on the dismissal hearing. I am just deducing that it didn't happen. The dismissal did not occur because the case is here now.
Your Honor, I believe the motions to dismiss haven't been heard or dealt with. There's another case because there's apparently 3 separate cases now against my defendant, my client. If Mr. Gonzalez needs some guidance, I'd be glad to talk to him, and if I can straighten him out and see if there's a conflict, that I can refer him to an attorney that it might need, because he looks like he's totally lost on these matters, and that might have an effect on how we proceed or how fast we proceed on these cases, Your Honor. But I believe the motions to dismiss haven't been heard.
Is it your motion, Mr. Morales?
I believe it's one of my motions. So do you need I'll submit a request for a hearing on that motion.
Okay, please do that. If there's anything that is outstanding that requires a hearing, please email Ms. Nieto with your filed pleading to get the matter heard. Ms. Payton, were you going to say something?
Your Honor, I was just going to add, it's my motion to dismiss as well. They have not been heard. My understanding of the notice of dismissal DWAP, because we saw that too, and we talked to the clerk, and she said that was sort of that judge's standard operating procedure to set something that was either you show up for a scheduling conference or it turns into a DWAP conference, and then of course the case was reassigned to you. So we're all here, and as far as we know, the case is still proceeding against all parties.
Okay, so again, anything that has been filed, any motion that has been filed that the proponent wants to have a hearing on, please submit the request to my court coordinator for a hearing. For now, the only thing we're going to cover is the scheduling and the trial date. Mr. Gonzalez, Mr. Morales, I don't have any idea of whether there's some conflict there. Mr. Gonzalez, yeah, I can't give you any legal advice. All I know is that the case is proceeding and for now, and we will get our scheduling order. Like I said, with all of the hearing dates, they all will be via Zoom, just like we did today, and the login will be the same. So please note that. The entry of the scheduling order, the hearing for the entry of scheduling order is in 2 weeks. So that puts us at March 11th at 3 p.m. What happens is if the court receives the scheduling order signed off on, approved by all parties, which includes you, Mr. Gonzalez, then no one needs to appear. But if I don't have that by, March 11th at 3 p.m., then you all need to appear and you will appear just as you did today. Does that make sense?
Yes, Your
Mr.
I'm sorry. I'm sorry. No, ma'am. Could you explain that again, please?
So I have set a trial date of April 17, 2020, or I'm sorry, April 16, 2027.
Yes, ma'am.
In this type of case, there needs to be an order agreed to by the parties, designating all the deadlines, all the rules, the mediator that will be agreed to by the parties. So you're going to be ordered to go to mediation by a date certain. All of that is in the scheduling order. You all will receive the court's proposed scheduling order. And there you will see all the deadlines, all the rules that will apply to how this case will proceed. Okay. Once you all have agreed on that scheduling order, it needs to be returned to the court. The deadline to do that is March 11th, right? At 3 p.m. If I have not received an agreed scheduling order by that deadline, then you all need to appear just as we did today. What else, Mr. Gonzalez?
Well, I mean, I guess I was just understanding by reading the letter that everything was dismissed. So
That's
it's
not
not
a letter that says it's dismissed. It's a letter that says there is a hearing on motions to dismiss.
okay.
That, I think, changed because that court transferred it to me. So, as I said, if there are any outstanding motions to include any previously filed motions to dismiss, you make your request for hearing on those motions with my court coordinator and we'll get them scheduled. Okay. What else? Anything else?
Not on my part, Your Honor.
Okay.
Nothing
Mr.
from
Gonzalez, feel free to call this court. This is the 210th District Court. If you have any further questions about scheduling, the scheduling order again is due to be entered on March 11th. Okay.
Thank you, Your Honor. Can we be dismissed?
One second. Mr. Gonzalez, do you have anything else?
No, Your Honor. I'm not too. I'm just a little confused, but I guess I'm just going to do what you want me to do.
No. So I just want to make sure you have an understanding. There is a document, a proposed scheduling order that is going to be circulated amongst all of the parties to include you. Okay?
Yes, ma'am.
Okay. Yes, ma'am. Yes, Ms. Payne.
Your Honor, I was just gonna say for that purpose, could we ask Mr. Gonzalez to provide like an email address? I don't think I have contact information from him.
We don't have an email from Mr. Gonzalez?
I don't think he's made an appearance in the record.
How did you get notice of today's hearing, Mr. Gonzalez?
It just came in the mail, Your Honor. I received a letter in the mail.
do you have an email?
Yes, ma'am.
Okay, what is your email?
It's DSGONZAL 64 at yahoo.com.
Okay. So it looks like my court coordinator is telling me that I guess the other court let you know about today's hearing. So notice will be electronically filed. And now that we have your email, we need to add that. So Ms. Duran, if you're there, we need to add Mr. Gonzalez, his email to the eServe on this case, so that he receives those notices.
Okay, yes, Judge. I'll do that.
What else is missing now is what I'm wondering. Have you accessed the case online, Mr. Gonzalez?
No, ma'am.
Okay, so everything is done online and through e-filing. And so I'm not positive if you have to register. I'm not sure exactly how you do that. Ms. Uran, do you know how is a self-represented supposed to access the case?
So there is a website that you can do for ProSares that we give out. It's texaslawhelp.org. And there, I believe there's a step-by-step on how to access and register for e-file, how to file the documents, and sign up to also receive notification for anything else being filed into the case.
Okay. So it's texaslawhelp.org. Is that right?
Yes, that is correct. I'll also put it in the chat as well.
All right. All right. So that's the starting point, Mr. Gonzalez. Okay, you need to sign up for the notifications. You need to access it because everything is done via online access.
So any information or anything that I need to do will be sent to my email address, I'm assuming?
If I think you have to register on the case. So we have to make sure, I think the clerk is attaching your email, but you need to go to what is it? texaslawhelp.org. There it is. It's in the chat.
Okay. I mean, do you mind if I just grab a pen real quick?
You should. Who's next?
Sorry about that.
texaslawhelp.org.
Texas. I'm sorry, Texas. What was that?
texaslawhelp.org.
Okay, so I have to log into there.
Ms. Duran, would you please explain it to Mr. Gonzalez?
Yes, it's a website for that we give out to all people who choose or who are choosing to represent themselves. There you can do your own research on what you may need, what anyone is asking from you, and then there's also it provides a step-by-step on how to register and file for things on Texas e-file because that's where all the other parties will be adding their documents.
So, Your Honor, he's not on the serve list. So, could we get we got the email? Can we get his phone number?
Mr. Gonzalez, do you have a phone number? I believe Ms. Duran is adding him. Is that right, Ms. Duran?
Yes, I am adding his email.
What's your phone number, Mr. Gonzalez?
915-346 2885.
So make sure now that you're on the eServe list, anything that gets filed in this case, Mr. Gonzalez, will be served on you via email. Okay, so make sure you keep track of the email. Anything else?
Nothing further from the plaintiff, Your Honor.
Nothing further from David Morales.
Nothing for me, Your Honor. Thank you.
Mr. Gonzalez?
No, ma'am. So this case is still continuing on then. Am I correct?
Yes.
Okay.
Anything else? Mr. Gonzalez, anything else?
No, ma'am. No, ma'am. Nothing at all.
Much. Everyone is excused. Thank you.
Thank you, Your Honor.
I have another case, Your Honor, so I'll stand by.
Okay. All right. Who's next, Mr. Nunez?
Judge, let me let some people in, and the first one is gonna be on page 3 in the top of the page.
All right, we'll start with 3384. Calling cause number 2025 DCV 3384, Rita Gonzalez versus Froilan Rapato. May I have announcements, please?
Good morning, Your Honor. William Moss for the defendant, Ms. Froilan Robato.
Good morning, Your Honor. Jameson J. Douglas, counsel for plaintiff Rita Gonzalez.
And scheduling status conference, folks. Are y'all ready for a trial date?
Yeah, I think we could be ready for a trial date. We do have depositions set for March 9th. We had part of the deposition occur earlier, but there were some technical difficulties that we had to move it. So March 9th is the remainder of the deposition that's set.
So I'm looking at a trial date of February 12th next year. Any issues with that?
No issues.
Okay, so that'll be your trial date. We're going to circulate, or you all can create a scheduling order that mirrors the court scheduling order. Please agree to your mediator, include it on the order, return it to us before March 11th. The entry of that order is set at 3 p.m. If we have your order back, agreed to and good to go, you don't have to appear, otherwise you do. Anything outside of those dates, please send your request for hearing to the court coordinator, Ms. Nieto, and we'll get you scheduled. Okay?
Thank you, Your Honor.
Thank you for your time, gentlemen. If you don't have anything else, you are excused.
Yes, ma'am. Thank you, Your Honor.
Thank you. Bye-bye. Who's next?
Judge, on same page, page 3, do you want me to call it?
Sure.
Calling cause number 2025 DCV 2025 Grant Fam Transportation LLC versus TA Operating LLC et al. Announcements, please.
Good morning, Your Honor. Francisco Ortega for plaintiff.
Good morning again, Your Honor. It's Annie Jacobs for TA Operating LLC.
Good morning, counsel. Yes, Miss Jacobs. We had a time confusion. She was here since earlier, Mr. Ortega. We should have called you because we were here earlier too. Are we ready for a trial setting?
There's been some written discovery, Judge, by defendant. I think that we responded to in late November. I got to do some written discovery and probably maybe take 1 or 2 depositions on my end. There hasn't been any settlement communication, so I don't know if maybe mediation is something that's in the horizon after we complete written discovery. But if the court wants to set a trial setting, we could do that.
So I just assume, 2020, I said I was going to stop saying this, but I'm going to say it. 2026 has been a doozy. And I just assume give you a trial setting, even though that means you all are really going to try and go to mediation, say in 90 days, 120 days, whatever it is, because you'll have your mediation deadline. And at least that way I don't have you all waiting, 4 months down the road and then find out that you're actually set at the end of 2027, that I think even thinking that gives me like a little bit of a heart attack. So with that, the trial date I would have now is February 12th of 2027, right?
That works for me, Judge.
I'm just double checking my calendar, but I. You said February 12th?
I think so.
It'd be set on a Friday.
Yes, trials
Okay.
jury selection starts on Friday and we start evidence on a Monday.
Perfect. Yes, that works for me.
So what that will mean practically in terms of your mediation is the mediation deadline falls the day before your final civil pretrial, which is generally 30 days before the docket call or your trial. So, we're talking about the end of the year, to complete mediation. So that should be a good window. We'll do that. So please circulate the scheduling order, agree to it, return it to the court before the 11th of March at 3 p.m. and you will not have to appear for the entry of that order. Okay?
Understood, Your Honor. Thank you very much.
Thank you. Anything
Yes.
outside of those dates, please send your request to the court for hearing and we'll get you set. Okay?
Thanks again.
All
Have
right,
a
thank
good day.
you.
Thank you very much.
You too, Your Honor.
Who's next?
Judge, I don't have anyone appeared yet for page 3, bottom of the page.
Hmm.
Do you want me to go and call it or skip to someone I do have?
On which one? On 3480?
On 3480, Judge.
Oh, well, let's call it. It was set at 10:15.
Yes, ma'am. Calling cause number 2025 DCV 3480 Omar Reese versus Amanda Lara. Announcements, please.
Nobody's in the waiting room?
No, ma'am.
And Ms. Udan, can you tell me if they opened the notice of today's dismissal hearing?
Judge, for whatever reason, lately, e-file hasn't been letting me see if they've been opened or not, but it does show a status of served.
Okay. Yeah, the order setting hearing was back on January 5th. Let me see. All right, it's going to be dismissed for failure to appear today. Thank you very much. All right, who's next? What happened to the 13525 right before that, Mr. Nunez?
3525 was canceled earlier, Judge.
Okay. Ándale pues, who's next?
Judge, we have everybody here for, I believe, 2447 on page 4. Do you want me to call that one or do you
No,
want me to leave 11 o'clock?
No. So this is the one I mentioned yesterday. They're set at 2 different times, which is
Yes,
why
ma'am.
I asked the attorneys to be notified to just come at 11 o'clock because I think we have quite a bit to cover. So is anyone else ready other than Ventura Martin Rodriguez Venegas? You're here on 1873, Mr. Silva?
Yes, Your Honor. I'm
That's
here
okay.
for that one as well, Your Honor. Sorry.
Let's take care of that one.
Yes, ma'am.
2025 DCV 1873 Hector Maldonado et al. Versus Elias Ruiz Santiago et al. May I have announcements, please?
Good morning, Your Honor. Omar Silva for the plaintiff, ready?
Kote Bazam on behalf of USAA.
For super scheduling status conference, let me see. What is missing here? Or are we ready for a trial date?
Your Honor, before you give us a trial date, we amended the petition. We requested a new citation for the new defendant. We still haven't served them. So if we can get maybe a status in 45 days to serve the new defendant and then before we get a trial date.
Okay. All
Your
right.
Honor,
Yes,
we've
Mr.
been-
Azam.
We've been coordinating with the insurance adjuster to see whether coverage extends to the new defendant driver. But there's a lack thereof of insurance or it's missing, but we're under the impression that it may or may not exist, but we're trying to retrieve that information. But if we retrieve that, we'll definitely let opposing counsel know.
All right, so we'll reset this scheduling status conference for 45 days. Okie doke.
All right.
Yes.
Thank you.
Thank you, Your Honor. Maybe you'll just
Yeah, you all are excused unless you have something else.
or excuse, sorry. Thank you.
You.
Oh, Your Honor. Thank you.
Do we have Mr. Flores here? Mr. Flores on 4775? Did he leave? All right, well, I guess we can start on the motion to compel, but I feel like, Ms. Razo, what are you here on? 0587?
On page 5, Judge, on 0587, the Wells Fargo.
Yes, Your Honor, this is Samantha also appearing on behalf of Plaintiff Wells Fargo.
Yeah, default. Well, hi. It's like hodgepodge docket. So if I start on it's a little too early for me to call the default. And the only ones that are ready are the ones that have the law. It's Ms. Raza, you're gonna have to wait a minute.
Of course. That's fine, Your Honor. Thank you, Your Honor.
Motion to compel. Motion to compel. Calling cause number 2024 DCV 2447. Ventura Martin Rodriguez Venegas versus Mountain Star Constructors et al. May I have announcements, please?
Lara Brock and Luis Javier Espinosa for the plaintiff.
Victor Serrano on behalf of Mountain Star Constructors, Your Honor.
Randy Grambling on behalf of EPX Construction.
Clint Eccles for Furman Malooly Development.
Morning, Your Honor. Nicholas Jimenez on behalf of EPPX Property Management, LLC.
1 second. Good morning. We are scheduled this morning on several matters. The first one at 10:15 is the motion to compel. Give me 1 second. All right, Ms. Brock, you may proceed.
Thank you, Judge. Just by way briefly of background, because there's so many parties that are here, my client was employed to work at this new development, commercial development that he understood was being run by EPPX. He was hired by Mountain Star Constructors. Initially, we sued a company that was an LLC, Mountain Star Constructors, and then during the initial discovery in the case, we found out that Juan Gonzalez was doing business as Mountain Star Constructors, that Mountain Star Constructors LLC was trying to stop him from getting shirts printed and that kind of stuff. So we had identified the wrong Mountain Star Constructors. So before the expiration of the statute of limitations, we found that this was Juan Gonzalez doing business as, and we brought him into the case. Over the course of the case, we've tried to determine who owned the forklift that caused our client's injury, who was it out at the project that was controlling the work, in order to have that evidence that we are going to need in the case. Unfortunately, though, Mr. Gonzalez has not responded to any party's discovery requests, including mine. We sent discovery back on November the 4th to Mr. Serrano for his client. We also asked him for his responses to Furman Malooly's discovery requests and have not ever received a response. 2 days ago, Judge, we got an amended answer. So there is some participation from Mr. Gonzalez, but despite our attempts to reach out, despite our motion to compel, we've just never received discovery responses from them. So we would like this court to compel responses, waiving objection because of the untimeliness so that we can get this moving. Because as you can see, some of the parties have filed summary judgments. I'm trying to get documents from the company who brought my client onto the job site so that I can meaningfully conduct depositions of the other remaining defendants. And so it's impeding our ability to move forward.
Okay. All right, Mr. Serrano.
Yes, Your Honor. I've been in contact with Mr. Gonzalez, and he is still gathering the documents for me to then tender to plaintiffs and Mr. Eccles, Your Honor. I will do so within the next, I'm hoping within the next 2 to 3 weeks, Judge.
All right, so that seems simple enough to me. The motion to compel is granted. The deadline is going to be, where does that put us? We will reconvene on the 18th. The March 18th. March 18th. We'll do that at 9 a.m.
Judge, I'm actually set for a hearing in federal court at that time. On the 18th, actually two of them.
Okay. So we can do 11 a.m.
Yes, Judge, no problem there.
All right.
Judge,
Miss-
I do see on March the 18th that we have our final civil pretrial conference set at 11 a.m.
as well? Okay.
that day already.
Okay.
It would be my intention because of this holdup, finding the correct Mountain Star constructors, trying to get this discovery from them, that I'm going to move for a continuance. I just want to put that on the court's radar. We were trying to get these hearings and things set in order to be efficient with your time, Judge.
I would encourage you when you file that motion, I don't know if there's an agreement to have it filed soon, and request the hearing anticipated it'll be set on that day as well.
Okay, thank you, Judge.
Thank you, Judge.
All right. Okay.
Should I submit an order for this
You're
motion
reading
to
my
compel,
mind.
Judge?
That's the next thing that was gonna come out of my mouth was please send me the order with the applicable deadline. And
May I write or state in the order, Judge, that any objections, because he's mentioning submitting documents. We sent interrogatories and requests for production. May I note that objections are waived as untimely at this point?
I don't think I'm quite there. Let's see what the 18th bears out.
Okay, thank you, Judge. I just wanted to be clear for the order.
Thank you. All right. Anything else on the motion to compel?
Not for my position, Judge. I think we just want it.
So with that, I'm going to take like a 2-minute break, which is not a break, so I can get Ms. Razo's case taken care of and a few of these other folks, and then we'll address the summary judgment.
Okay, thank you,
So
Judge.
stick around, please. Stick around. Okay. Who's next, Mr. Nanez?
Judge, it's 1 minute so we can call Ms. Russell's case. And
Who's Mr. Perez here on?
Good morning, Your Honor. I'm here on the motion to dismiss, the 91A motion to dismiss for Blas Segura as my client. I think Mr. Flores is here on this case as well.
Yes, Your Honor.
Okay, this is the 10:30. Okay. All right. Calling cause number 2025 DCV 4775 Jaime Niens versus Evelyn Godinez. May I have announcements, please?
Gabriel Perez, good morning, Your Honor. Gabriel Perez on behalf of the movement on today's motion, the defendant, Mr. Blas Segura.
Is this it? Oh, gotcha.
René Flores, in behalf of the plaintiffs, Jamie Hans, individual, and on behalf of AM.
Sorry, Odyssey wasn't cooperating. All right, Mr. Bettis, you may proceed.
Thank you, Your Honor. Good morning. Your Honor, I'll kind of make it brief. I know the court's got a docket today this morning. So we filed our original motion and an amended motion, and we'll just go off the pleadings as the 91A requires. Looking at the pleadings of the plaintiff in this case, it's a dog bite allegation against Mr. Segura and the other defendants. And the petition, I've seen, looking at the amended pleading that was filed on, looks like
13th?
correct. There we go.
Okay.
What it has in the amended petition, Judge, it does basically, it alleges that Ms. Godinez and Mr. Ramirez were the owners of the dog at this property there on Broadest Street. That, however, the addition of additional language basically states that, I believe at the factual basis, on information and belief, all defendants were aware of the dog's aggressive behaviors prior to May 21st, 2025. That's the blanket statement that they used to bring in the homeowner, Mr. Segura, who I represent, into this dog bite allegation, was that, on information and belief that my client, as the owner of the property, should have or had knowledge of this dog's tendencies. That's what the allegation of the petition includes. And so there is no basis. There's nothing stating that this was a second occasion, this was a third occasion, that, at least to put the homeowner on notice. The allegation simply states, upon information and belief, all defendants knew of the dog's tendencies prior to the incident. That's the sole basis for keeping Mr. Segura as the homeowner on the hook for the bite of this child. But they admit the dog was owned by the co-defendants, the other individuals named in the lawsuit. 91A, I do understand, I've seen the response, and it does allow for the court to use liberal pleading standards and to kind of, make reasonable inferences therefrom. But I have case law that I can provide to counsel and the court judge, and I know this court's seen it before. It's a fair notice pleading standard. All parties are supposed to be able to ascertain from the petition, from the lawsuit, what is the basis for liability in this case for the allegations made against them. Well, obviously, as to the individual dog owners, that's great. That's straightforward. They owned the dog that bit the child. That's easy. That's easy to ascertain. But Mr. Segura, all it states is that, one, he owned the property, and two, all defendants, and it doesn't say, I assume all, meaning all three, but it says all defendants should have had knowledge of the tendencies. Well, I think that's this amorphous concept of they should have. Well, it doesn't say they did or they had knowledge. He says they had knowledge of prior to the incident, but how? Well, it did, like I said, there's various ways the plaintiffs could have addressed this issue. This pleading standard to state this dog was responsible for 3 other bites, or they had warned them, they had sent a letter, something. There's nothing indicating that Mr. Segura had actual knowledge of this dog's tendencies prior to the incident that occurred in 2025, Your Honor. And so we feel that based off of the pleadings that were filed, even the amended pleadings, it still doesn't rise to the level of providing notice as to what the allegations are.
All right, Mr. Flores?
Your Honor, respectfully, I do believe that the pleadings do rise to a level of notice. They are enough to put the defendant aware of the situation. And as defense counsel stated, this petition does not state that they should have, but they state that they were aware of the dog's aggressive behaviors. Not that they were noticed on previous accidents or previous bites, but of the aggressive behaviors, which is different to what he's requiring or requesting of evidence of prior notices of prior bitings. We don't have that. But at the end of the day, I believe that the opposing counsel is trying to skip the front of the line and avoid discovery process. And I think the plaintiff has very clearly stated in his petition and is enough to put the defendant aware of the notice. Not only that, even if we take into consideration the month-to-month basis lease agreement that they have even provided, which we would be actually ignoring the fact that this should be the 91A motion should be only ruled based on the petitions itself, not on the extra evidence that the defense counsel has provided. But even if we were to take that into consideration, the lease to lease month that they had also kind of infers that the defendant was aware that the dog had been there, or at minimum would actually go through a monthly basis of checking their own property. This is not a 12-month where they might come back to the property every 6 months to check maybe the water or check the air conditioning, the filter. This is a month-to-month lease basis, lease agreement. It's implied that they were checking their property prior to this incident, and it's in our experience that this happens very common, where landlords have in writing that they wouldn't allow the dog or any dog to be in the premises, but repeatedly we have outside evidence where it's discovered basically found out through discovery that there's text messages that they allow, and that doesn't change the lease or the agreement. But there's other notices that we would basically encounter in these kind of situations. We have hundreds of dog bites where now it's been reoccurring again and again, Your Honor. And again, if we go back to the petition itself, there's enough inference and notice, which is what the 91A motion only requires. At least that is our position, and I don't want to deter Your Honor from moving outside of what the requirements are. And
Okay. Anything else on the motion to dismiss?
No, Your Honor. I think the responses and then the pleadings are sufficient for the court to consider that.
Mr. Flores, anything else?
No, Your Honor. I think the
Okay. All right, the court is going to take it under advisement. I'll have a ruling for you very soon. We are going to set this for a scheduling status conference, no matter what happens, in 30 days.
Perfect.
Thank you, Your Honor.
Thank you very much.
Co-counsel.
Thank you, Judge.
Pleasure.
Have a good day.
And Renee, if you want to give me a call later, I'll let you know that, we can talk about it.
Okay. Thank you, Counselor. Pleasure.
Razzo. I think Miss Razzo is next.
Yes, good afternoon, Your Honor.
Thank you for patiently waiting, Miss Razzo. Let me call your case. Is anyone here on behalf of Gilda Moriel?
No, ma'am, no one in the waiting room.
Calling cause number 2025 DCV 0587, Wells Fargo Bank N.A. versus Gilda G. Moriel. May I have announcements, please?
Samantha Rosso appearing on behalf of plaintiff Wells Fargo Bank N.A.
And Miss Moriel has not appeared. We have not received any contact. You may proceed, Miss Razzo.
Thank you, Your Honor. We are here on plaintiff's motion for default judgment, which was filed on December 10th of 2025, which is based on a defaulted credit card agreement. Our petition was filed on February 5th of 2022, and the defendant was served with citation and petition on July 3rd of 2025. The citation and return of service have been on file with the court for at least 10 days, and notice of hearing was provided to the defendant on January 29th of 2026, and no answer has been filed by the defendant. Along with that motion for default judgment, Your Honor, we submitted an affidavit of plaintiff's employee who attests to having personal knowledge of the business records that are maintained and kept for Wells Fargo accounts, including those of the defendant in this matter, which are attached thereto as exhibits A, B, and C, and those prove up the record. Exhibit A is the consumer credit card agreement, which states that it is a contract, the terms of which are accepted by using or activating the account. Exhibit B is the account statement that evidences the last payment received from the defendant on the account, and that is in the amount of $268 on January 11th of 2024. And then Exhibit C is that final account statement prior to charge-off, which evidences the $11,881.61 that is owed to plaintiff, and that contains a notice of default and acceleration based on the defendant's failure to make payments as due, which the contract does state is an event that constitutes automatic default. And then in addition, we have also submitted the declaration of Thomas Sellers, who is an attorney with our firm, because plaintiff has retained our firm in this litigation and is seeking attorney's fees under Chapter 38 of the Civil Practice and Remedies Code and the contract. Mr. Sellers has 17 years of experience in commercial litigation and other litigation at both the trial and appellate court levels. The hourly rate for his services is $190, and he provides that attorney's fees in the amount of $800 through obtaining default judgment are reasonable and necessary for the legal services provided in this case, based on the time and labor that was required, the results obtained thus far, his experience, reputation, and ability, and the usual and customary fees charged in El Paso County for similar legal services. And we have also included the military service affidavit and the Department of Defense certificate that shows the defendant is not on active duty, and the certificate of the defendant's last known address. And Your Honor, we are requesting that you please take judicial notice of the file and enter judgment as we have pled in the amount of $11,881.61, including those attorney's fees and court costs. And we further ask that the court dispose of all issues and parties.
So just to be clear in reviewing the motion, look, I did review the motion. I have 2 exhibits attached as exhibits 1 and 2. As far as I can tell, everything that you represented in the exhibits is contained within exhibits 1 and 2. And so those are admitted for purposes of this hearing. In addition to that, the court will take judicial notice of all the documents in the court's file, grant judgment as requested. If you would please provide the proposed order, the court will sign off on that.
Your Honor, and should we e-file that as a no fee document, or should we email that over through?
Ms. Nieto, please, Marissa Nieto, ma.nieto@epcountytx.gov. Honestly, we were in trial last week, and I know I received a lot of proposed orders on some things. Maybe you've sent it, but the best thing is to just send it now. And
Okay.
I'll sign off on it, okay?
Okay, yes. Okay, perfect.
All right, thank you very much.
Thank you, Your Honor. Thank you for, we appreciate your time and consideration of our motion. Will you excused?
Yes, have a good day.
You as well. Thank you. Your
And
Honor.
Mr. Valenzuela is here, maybe for Mr. Spencer. And Mr., I'm not going to be able to say your last name, Krozik?
Yes, Crofcheck is fine. Thank you, Your Honor.
Crosscheck. Mr. Valenzuela? Are you here for Mr. Spencer?
Yes, Your Honor.
Okay, that's what I thought. Calling cause number 2025 DCV 2924, Imelda Soto versus Vista Hills Healthcare Center. May I have announcements, please?
Felix Valenzuela, representing Mr. Spencer on behalf of plaintiff.
Good morning. This is John Crofcheck, movement on behalf of defendants Vista Hills.
Okay, bear with me 1 second. I don't know why Odyssey is so slow this morning. Okay.
Well, Judge, I might be able to make this a bit easier for you. We are asking for a continuance. I think we can resolve this matter. We just need a short continuance to be able to finalize some of the outstanding issues.
Are we in agreement?
No, Your Honor. We're not in agreement. This motion has been moved a couple times already. We'd like to move forward if possible, but we do concede that counsel has contacted us and indicated that there's a potential resolution on the horizon based upon the representations made.
So what I have is an amended motion to dismiss that was filed on January 9th. Let me see.
Yes, Your Honor.
Let me just look at a few things here. Oh, I see.
If I may, Your Honor, it was a motion to dismiss was initially filed. Plaintiff, subsequent to that filing of the motion, filed a non-suit. Our office then, in response to that, filed an amended motion to clarify the issue of the non-suit and how it did not make the issues of the motion to dismiss moot. And that's why the timeline of that looks kind of wonky.
So, but what I am seeing here is Mr. Valenzuela entered an appearance on the 30th of January. Is that right? And this was previously set on the 11th. Was that when we were in trial? I'm not sure if that's when we were in trial.
Yes, Your Honor, for the timeline of it, initially there was confusion over the non-suit, and our initial hearing was involuntarily canceled. And then the second time we presented, you were at trial, and we were pushed to this current date.
Yeah, why does it say disposed? All right. So we need more time for what, Mr. Valenzuela?
To resolve the issue, Judge, there's been some negotiations going on behind the scenes, and I think we're getting close to a resolution. I'm prepared to argue if the court would like to, though.
Yeah, let's go ahead and move forward. Go ahead, Mr. Crotchet.
Yes, Your Honor, we're here on a motion to dismiss with a request for a dismissal with prejudice and attorney's fees and costs as allowed and mandated by Chapter 74, which is the statute that governs healthcare liability matters. This is a case that was filed under Chapter 74, and an answer was filed by the defendant, at which point in time a deadline of 120 days was triggered such that plaintiff had to serve an expert affidavit outlining the basis for professional negligence in this case. There are two issues that are not in dispute here. There's no dispute that that expert affidavit was not filed timely, and there's no dispute that we filed our motion prior to plaintiff filing the non-suit in this case. If you look clearly from the statute, the two requested forms of relief, the dismissal with prejudice and the statutory fees and costs, are mandated. The statute specifically says shall be awarded in the event that the defendant files a motion subsequent to the failure of plaintiff to serve an expert affidavit within 120 days of the filing of the answer. All of those factors are at play here at Undisputed. If you look at the response that plaintiff filed in this particular for this instant motion, there's no dispute over the validity of the request for sanctions or the applicability of the statute. The only issue that's raised in their response is the amount of fees. And so I present to you, Judge, here today that the statute mandates that we get the dismissal with prejudice, and I have actually narrowed down and provided an affidavit of costs where I'm simply requesting 10.5 hours of work just on behalf of myself and not any of the attorneys at the firm in relation to the filing of this motion in preparation for argument at the hearing for the motion to dismiss.
All right, Mr. Valenzuela.
Thank you, Judge. So just to correct the record, this is not, the original petition was not a Chapter 74. There were 3 causes of action. One was a breach of contract, the next was fraud, and the last was negligence. There's no mention of Chapter 74 at all in the petition. And I think what defense counsel is failing to acknowledge to the court is that this case was closed. This case was dismissed. So the issue is very, very narrow. What they're asking for is whether or not the court sua sponte can reopen the case, undo the non-suit, and then dismiss with prejudice, which we believe that that is completely contrary to what the Texas Rules of Civil Procedure allow. The claims were already dismissed without prejudice, and they were signed by court order. The only issue that we agree is that the issue of fees. I think that survives pursuant to Rule 162. I think that stands outside, and the law is very clear that the issue of fees is already is still alive. So as the court is aware, there's no live claim that's remaining right now. There's nothing for the court to dismiss because the case was closed. The only issue is how much fees are appropriate given the lodestar factors. So here, let's see. Yeah, here we don't dispute the reasonableness of their fee requests. We do ask for a detailed breakdown because we know it's the defendant's burden to prove reasonable rate, reasonable hours, necessity, and a causal connection. Here, there's no specific time entries, there's no segregation of tasks, there's no necessity of each task. Some of the tasks that they put in their affidavit are tasks that would not have been performed but for their own filings and their own extension of their own motions. And so, for example, the non-recoverable categories, those should include the general case review that they cite to, the client consultation about the merits, the draft and original answer, monitoring filings, administrative case handling. Those have nothing to do with the instant motion dismiss, the reopening of the case, the non-suit. They talk about an expert, but that consultation is not necessary because the report itself was for what they say the validity of the claims, not as to whether or not the dismissal was appropriate or proper. So respectfully, Judge, we believe that the court is entitled to a breakdown to be able to analyze the lodestar factors. And so at this point, we don't think that the court has the authority to undo the non-suit, reopen the case, and dismiss with prejudice, but we believe, according to the rules of civil procedure and the Civil Practice Remedies Code, that the court does have actually the ability to assess fees.
All right, Mr. Crotchet.
Yeah, Your Honor, if I may, if you look at page 2 of plaintiff's response, they even reference Chapter 74. There's no reasonable dispute this is Chapter 74 case. This is a woman that was in a healthcare facility because she couldn't care for herself and was being treated by this facility. I understand that he's saying that for this argument, particularly today, but this is a Chapter 74 case. It's cited in their response. It's cited in our initial motion, and its logic would dictate that they're not disputing it because they filed the non-suit pursuant to our motion to dismiss, referencing Chapter 74. Now, the major issue, and where I want to clarify comments that were made by Mr. Valenzuela here today, is Chapter 7.4, and I've cited the case law in my briefing, specifically states that the forms of sanctions of dismissal and attorney's fees are part of the sanctions of Chapter 74. So both survive the filing of a non-suit, not just the request for fees and costs, but also the mandated dismissal with prejudice. So my clarification would just be that that is part of the sanctions that survives the non-suit. So that should be before Your Honor right now, as a form of sanction that is not something that has to be removed by the non-suit.
And Judge, I don't believe that the case law says that he cites to. For example, the Fox versus Hinder litter. In that case, the trial court had multiple settings for dismissal. It refused to decide, refused to decide, refused to decide. And that's what the appellate court said, no, you should have decided much earlier. And so, I mean, I think those cases are not on all fours with what we have here, where the case was active, it was live, non-suited, closed, and then now we're having the hearing on a dismissal when the case is already closed. So we don't dispute that fees survive. We don't dispute that at all, Judge.
Anything else?
That's all from our side, Judge. Thank you.
Nothing further from us either, Your Honor.
Okay, the court is going to take this under advisement. For my purposes, I'm going to have a status in about, I'll say 3 weeks, in about 3 weeks, but that's really, for my purposes, I mean, it's still a status. You still need to appear, but I anticipate ruling before then, okay?
Okay.
Thank you, Judge.
Thank you very
Thank
much.
you, Your Honor.
May I
All
be
right.
excused, Your Honor?
You all may, yes. Thank you for your time.
Thank you, Judge.
Who
Thank
do
you,
we
Your Honor.
have left other than the summary judgment?
Judge, we still have one on page 5, the last one, auto investments, at 11 o'clock.
Oh, well, are all my summary judgment folks still here? Yes?
I'm here,
Case
Judge.
management is.
I think since you all, there's no point in waiting 6 minutes. Huh? And we'll just take care of Mr. Miranda and Mr. Lopez after our summary judgment. Thank you for your patience, y'all. Is everyone ready? Let me see. Hold on a second. Am I ready? Right folder. All right. Let's get back on the record in cause number 2024 DCV 2447, Ventura Martin Rodriguez Venegas versus Mountain Star Constructors et al. Oh, you may have announcements, please. Just leave Mr. Lopez in the waiting room for now.
Laura Brock and Luis Javier Espinosa for the plaintiff.
Nicholas Jimenez on behalf of Movement EPPX Property Management LLC.
EPX Construction. This is Randy Grambling on behalf of that defendant.
Victor, go ahead.
Go ahead, Victor. No, it's all right.
Victor Serrano on behalf of Mr. Juan Gonzalez, Your Honor.
Clint Eccles for Furman Malooly Development.
All right, now at 11 o'clock, we're scheduled on the motion for summary judgment. Mr. Jimenez.
Thank you, Your Honor. May it please the court, opposing counsel. So as the court indicated, we have 2 pending motions, a no evidence motion under Rule 166AI and a traditional motion under 166AC. With the court's permission, I'll address the no evidence motion first, then briefly turn to the traditional motion. So, Your Honor, this is pretty straightforward. We filed a proper no evidence motion on January 16th, 2026. Per the rules, plaintiff's response was due February 18th, 2026. Plaintiff filed no response. So under Rule 166AI, the court must grant the no evidence motion. That notwithstanding, Your Honor, the motion is proper. Our motion identifies every challenged element with specificity: duty, control, breach, proximate cause, and gross negligence. And we have supporting case law for each, and that satisfies 166AI. And in fact, our own 8th District Court of Appeals approved this exact format in Hernandez v. Vasquez, which is 656 Southwest 3rd, 589 at 593. And in Vasquez, the court held that a motion listing every element, citing case law, and referencing plaintiff's factual allegations meets the rule's requirements. Now, that notwithstanding, Your Honor, here, no response means judgment must follow. The Texas Rule of Civil Procedure 166 AI is mandatory, and it states the court must grant the motion unless the respondent produces summary judgment evidence raising a genuine issue of material fact. Here, Your Honor, plaintiff produced nothing, you know, and unlike the traditional summary judgment standard, the old prohibition against judgment by default does not apply here. Summary judgment must be rendered absent a timely and legally adequate response by a non-movement. Additionally, nor is the court required to search the record for evidence on plaintiff's behalf. The Supreme Court just held in this last term in State versus $3,774. That's 713 Southwest 3rd 381. That it's not the trial court's burden to read any or every document in the record with no guidance from the non-movement. So here there is no guidance because there is no response. And going back to Vasquez, the 8th Court affirmed no evidence summary judgment even when the plaintiff did respond, but failed to produce sufficient evidence. Here, plaintiff didn't even do that. So for those reasons, a no evidence motion must be granted. Turning to the traditional motion, Your Honor, even without the no evidence motion, EPPX Property Management is independently entitled to judgment as a matter of law because the contract evidence conclusively negates duty and proximate cause. So, ultimately, EPPX Property Management is a stranger to this project. It's a property management company. The prime contract at issue here is between Desert Commons LP and EPPX Construction LLC. There's a subcontract between EPPX Construction and Mountain Star, defendant Mountain Star. EPPX Property Management, and this is important, Your Honor, it appears in neither agreement, not as a party, not as a supervisor, not in any capacity. And those are attached as Exhibits B and C to our motion. Additionally, we submitted a sworn affidavit from EPPX Property Management CFO, Jorge Gonzalez, also affirming these facts. Bearing all that in mind, here, EPPX Property Management had no duty. As Your Honor well knows, duty is a threshold question of law. Without it, the inquiry ends. EPPX Property Management didn't own, occupy, or control the construction project. It didn't retain or exercise control over the means, methods, or details of the work. And not only that, but the contracts allocate all means and methods and safety responsibility to EPPX Construction and Mountain Star. And that shows in Exhibit B, and that's sections 3.31 and 3.32, and then Exhibit C, the subcontract, sections 2.1 and 5.1. So in Gomez v. Saratoga Homes, that's a case that's cited in our petition, the 8th Court granted summary judgment for the actual property owner and general contractor under these same facts. Contractual disclaimers, which is what we have in those contracts, disclaimers of control and allocation of safety to the contractor. So if the property owner gets summary judgment, a non-party to the contracts with no ownership or control over the project certainly does. Also, Your Honor, there's no proximate cause. Even assuming duty, the Supreme Court's recent decision in Warner Enterprises, Inc. v. Blake, and that's 719 Southwest 3rd 525 at 533, holds that merely furnishing a condition that makes an injury possible is not a substantial factor. Here, Your Honor, there is zero evidence that EPPX Property Management or a representative of EPPX Property Management directed the work, controlled the equipment, which in this case is the forklift at issue, or did anything connected to this accident. Again, we have the sworn affidavit showing as much. So, Your Honor, since you can't establish, or the plaintiff can't establish duty or causation, there is no foundation for exemplary damages. And we've referenced CMH Homes, and that's at 15 Southwest 3rd at 100, I believe. So there is no evidence of extreme risk. There's no evidence of subjective awareness. And just to conclude briefly, Your Honor, both motions compel the same result. On the no evidence motion, plaintiff filed no response and produced no evidence. The law requires judgment in favor of EPPX property management. On the traditional motion, the undisputed contracts conclusively established that EPPX property didn't own the property, wasn't the general contractor, wasn't a party to any contract governing this work, and had no control over the means, method, or safety of the painting work. Also, it didn't own the forklift. You know, what happened here is that plaintiff sued the wrong entity. So for those reasons, Your Honor, we respectfully ask the court to grant both motions, render a take-nothing judgment, and dismiss all claims against EPP Property Management LLC with prejudice. Thank you.
All right, Ms. Brock, you responding?
Thank you, Judge. Yes, we'd initially brought suit and conducted discovery to determine which EPPX and how they were responsible. I think the evidence that we initially received from the companies showed what Mr. Jimenez stated to be true and to be the case. When he filed his summary judgment, I made sure to tell the defense attorneys, make sure if you all think that there's something here that's wrong and that EPPX management had control over this project and the work that's being done, please file a response. There's clear case law out of El Paso that if a party is dismissed on summary judgment, they cannot be designated as a responsible third party. So for the same reasons, we needed to give everyone an opportunity, but I believe granting summary judgment in favor of EPPX management appears to be appropriate. I don't believe that the evidence has shown or that any party has argued that there's evidence that supports that EPPX management is responsible for the incident leading to Mr. Ventura Venegas's injuries.
Okay. All right, and that is granted. We have orders. I have everything I believe was provided to me ahead of time. So thank you for that. What else?
Thank you, Judge. I anticipate there's another pending motion for summary judgment that this court has set for hearing next week, which would mean that the parties' responses are due today. Out of efficiency, Judge, I am taking the same position. I think initially there was a suggestion that perhaps Furman Malooly had that owned this forklift that was involved, but I don't believe the evidence has led to that. So that's going to be my position again. And so I'm just putting that on the record and before you, if we're going to do this all over again, I don't want Mr. Eccles to need to present that much effort if the other defendants aren't going to challenge that they should not be a responsible third party at the time of trial.
I appreciate that.
So you might have seen me look over because I had seen the motions. What I had failed to see was that the Furman, well, it says Maloney, but I think it's Malooly motion. I thought that was set today as well. So thank you for clarifying that for me. And I just noticed it right now.
Sure, Judge. I just don't want to waste everyone's time, and I appreciate you allowing us to appear this way.
So, Mr. Eccles, you know, we have it set. I mean, I'm all about like just following the step by step, but for my purposes with that representation, then I don't want to rule until we have our hearing date. Now, with that said, I'm happy to take it via submission, and we will not, unless I'm hearing something from someone else, we won't have to be here on the 4th.
I think that unless Mr. Grambling or Mr. Serrano intend on filing a response, that you could take that at the time next week when it's officially set. Any responses are going to be due by the close of business today. So if anyone wants to fight to keep these parties in and on the jury charge, then there would need to be a response filed.
So I don't know. Go ahead. Is someone going to speak?
This is Randy Grambling. I agree with Laura. Give us to the end of the day if we need to file a response. Please.
I agree, Judge.
So for my purposes, just know I'll be taking it via submission. It will not be a hearing. If you all decide you want it actually heard on that date, let me know and we'll do that.
Yeah, Judge, and this is Clint Eccles for Furman Malooly. If a response by anybody else is filed, I will want to still keep my oral hearing date for sure.
Okay, So I'll tell you this, that's absolutely fine. We can do that. I would just rely on you, Mr. Eccles, to let us know that we need it.
Okay.
Because if responses are filed, unless someone serves the court and says, hey, judge, we filed a response, which I'm not saying they wouldn't do that, but if they forgot to let us know, I bet you would know, and you're going to come tell me that you want your hearing. How's
Okay.
that?
That sounds like a plan.
Okay. Okay. Yeah. So it'll stay there. Just know that unless I hear otherwise, it's going to be via submission. Ándale pues. Okay. So I have my orders. So what else? Anything else for today? I saw Mr. Grambling after the motion to compel throw something in the chat. What was that?
Basically, I think that if we have a pending trial setting pretty tight, we're probably going to need to get a continuance. And I think you earlier indicated to go ahead and file the motion. So I offered to draft a motion and
Okay.
circulate it.
Okay.
Yes, and Judge, I'm sorry, I was trying to clear out some of these parties before trying to move forward with scheduling a continuance and trying to get all of that done so that we could kind of clear the deck. I didn't want to take depositions of some of these parties, knowing that Mr. Eccles and Mr. Jimenez's companies were then going to have to pay for them to attend the depositions that I was trying to set. So I was trying to clear the deck a little bit before conducting discovery. I do see on our conformed agreed scheduling order, it has the final civil pretrial conference beginning at 10 a.m. on March 18th. It does not state whether that is in person via Zoom, and I apologize. Our office failed to clarify whether that was 10 a.m. Mountain or Central Time. I would presume Mountain Time.
It is Mountain Time and it's via Zoom. The only thing that is in person, even the docket call, unless you request it, is via Zoom.
Okay, thank you, Judge. I just wanted to make sure that we were planning in advance.
And it sounds to me like that is still a good date to hear the motion for continuance and talk about things because we will have cleaned up, as you put it, Ms. Brock, by that time.
It can be, Judge. The only thing I hate to have a hearing and not fully present to you everything that I anticipate we're going to need at a final pretrial conference. Or I know we agreed to mediate with Carl Green. I love to mediate with Carl Green. I have no problem doing that. I just know that we're not going to be in a position to have a meaningful mediation without wasting the party's time and money on the deadlines. And so I just apologize in advance as this has taken longer to sort through. So I'm just apologizing to the court.
So no worries. As much as I get bothered that folks don't always adhere to that mediation deadline, I think I'm going to be flexible here because I think we're moving this. And so let's just stick to the final civil pretrial. Well, the summary judgment that is still set on the 4th via submission, maybe. And then the final civil pretrial date, although I know the mediation deadline is the day before, I get it. We're not going to be there. And we're going to have our motion for continuance on that date. See?
Thank you, Judge. And yes, so we'll have the continuance, the motion to compel kind of follow through if we still need it from Mr. Serrano's
Correct.
client, and this final civil pretrial all on the 18th via Zoom at 10 a.m. Mountain Time.
One question. Are we going to have all our pretrial papers by the pretrial hearing?
Yeah, maybe I'm misunderstanding. I hope I'm not. I'm kind of thinking no one's going to oppose the continuance, right?
That's correct. That's correct.
I would hope not, Judge. I think it'll just be.
So if no one's opposed to the continuance, then to me, we're using the final civil pretrial as a date to get this case on a new trial track. So no, to answer your question, like if the continuance is generally agreed, then those deadlines are not going to apply, just like your mediation deadline's not going to apply. And we're going to use that date to reconvene and get this back on track.
Perfect. Thank you, Your Honor.
Great. Yes. Thank you, Judge. I know I was going to try to get everything prepped, but.
Okay, the only thing I might have outstanding, and I apologize if I'm wrong on this, Mr. Eccles, is a proposed order, but you might have sent it. It might be in my emails. So.
Yeah, I'll check. I mean, I'm positive I prepared one. I'll need to make sure that you have it.
Thank you so much. Okay, anything else?
No, Your Honor.
All right. Y'all are excused. Thank you for your time today.
Thank you, Judge.
What's left, Mr. Nunez?
Just our last one, Judge, on page 5, bottom of page, auto investments. Let me
Yeah,
let them in,
bring 'em in.
Judge.
Yes, please. Not too bad, not too far behind. Oh, Mr. Lopez, Mr. Downey, I felt so bad. We had an extended hearing on another case and they were here since about 10:15 and they were set on both times, 10:15 and 11. And we were done. And so I said, well, let's go. And then, you know, my other 11 o'clock, which was you guys, will have to just wait a minute. And the second I called it, you all popped into the waiting room and I felt very bad about that. But it was only 12 minutes now, late.
That's all right, Judge. Not a
Judge,
problem.
that's earlier than most courts, so thank you. We appreciate it.
So scheduling status conference, are you all gonna tell me you're ready for a trial date or you're gonna tell me give me 30 more days or 60 more days?
Judge, so Blake and I met. We're trying to resolve this informally. And really it's a lease case, so it comes down to some accounting questions. And so he's provided me with some numbers that I need to look at and have either my client or an accountant look at to see if, because the numbers are really going to control what happens in this case. So if we could get a reset, Judge, that would be great.
How much of a reset? How long?
Judge, although
sorry,
I'd
go
like
ahead.
to, Mr. Lopez, I'd like to do 30 days just to keep pressure on both of our clients.
30 days. You got
I don't know if that's sorry, although I'm having a little bit of pushback from the client on timing on this
That's
one.
all right.
30 days is good. It seems like that's what we did last time, so that's fine. 30 days
Judge,
is good.
I failed to appear last time. I'm sorry.
You did? Ooh.
Yes, ma'am. Something happened. I was expecting lashings today, but I'm glad it's via Zoom.
Oh, Lord.
But what I was going to ask, Judge, it doesn't look, I think you orally admitted me in the case because I substituted for Mr. Maldonado, but I'm not listed as counsel of record yet. So because I think you ordered it from the bench. I just need to be added. I've got the motion on file. I think I might have filed it twice.
So I have an entry of appearance now on the 23rd by Jordan Hartshorn.
Yes, Judge. I was supposed to be arguing in the Southern District of New York today, but the judge is under a lot of snow, so they canceled the hearing. So she's my co-counsel,
Okay.
and was going to appear just in case I'm not available.
Okay, so Ms. Duran, I do see that there is a motion for substitute counsel, and I feel like you've done that since way before. Let me see.
We did it like 3 or 4 months ago, Judge. Judge, it was odd the way that Scott Holston and I handled some of the substitutions. So but I don't think that I think you entered the order orally. I can send a brief order if that makes it easier to get it filed.
I'm just checking my emails real quick because I feel like I signed off on the order granting your motion to substitute back on October 18th.
Yeah, that was my recollection too, Judge. I'm not getting service in the case.
So I'm gonna just pull up the order that was sent again. And I'm gonna resend it so we can get that filed. And then Ms. Duran, if you'll just follow up, please, and make sure that Mr. Downey is replaced, I guess.
Yes, Judge, I will.
Let me do an email, just do a fresh new email. Let's see, MA and gotcha. Okay. And this is, let me put a cost number. All right. Done again and good to go. 30 days.
All right. Thank you.
Thank you so much, gentlemen. Have a good day. Bye. You too. Take care. All right. So now with that, that's everything, brother.
Yes,
Long
ma'am.
morning.
I'm
Okay.
calling you 3 o'clock waiting just to confirm it, Judge.
Oh, so it's today? I thought it was tomorrow. Let's get off of YouTube, please.
Oh, no, my mistake, Judge. It is tomorrow. I mean, Friday.
Friday? This is the 26th.